Good afternoon, good morning, good evening, everyone. I'm Gloria Gaggioli. I'm the director of the Geneva Academy of International Humanitarian Law and Human Rights and professor at the University of Geneva. It is my great pleasure to welcome you to this 2021 Current Issues in Armed Conflicts online conference. It is the first time that we have this conference organized online. This is for both sanitary and organizational reasons. But I'm glad to see that you are so numerous to attend it in this new format. So thank you for being with us today. The STIAC conference was launched already in 2017, and initially it was launched with the University of Essex, an institution with which the Academy has always entertained strong ties. At the time, Professor Lobel was also our Swiss IHL chair, and as you can see, he has left a very positive legacy. So this annual conference is conceived really to provide a space for experts, practitioners, diplomats, academics, and the civil society representatives to discuss the legal and policy issues that have arisen in past and current conflicts, and especially with the focus on issues related to classification. So why do we find important at the Geneva Academy to organize a conference that is focused on the classification of armed conflicts? Well, there are several reasons for this. First reason is, as we all know, that classifications of situations of violence is essential from an international humanitarian law perspective. This specific body of international law, that is IHL, applies only to situations of armed conflicts. So be they international armed conflicts, I mean by that conflicts between states mainly, or non-international armed conflicts, which are conflicts that are opposing one or more states to organized armed groups, or conflicts that are pitting organized armed groups against one another. So if a situation does not amount to an armed conflict, then IHL is not applicable. But human rights law, which is applicable at all times, would provide the necessary protections to individuals. Instead, if there is an armed conflict, be it international or non-international, then international humanitarian law kicks in and will provide additional and very specific protections, while at the same time allowing, or at least not prohibiting, certain conduct, such as the targeting of legitimate targets, incidental civilian killings and damages, security detention, and so forth and so on. So in brief, whether or not an armed conflict exists makes a huge difference in terms of applicable legal framework, as well as in terms of the amount and type of protections that will be afforded to individuals. A second reason why classification matters for us at the Academy is that classification has been really at the center of our research activities for a long time. Indeed, the Geneva Academy monitors closely situations of violence around the world in order to determine when a situation becomes an armed conflict, and also to determine whether what will be that classification, international armed conflict or non-international armed conflict, and what will be the applicable norms. So this year, for instance, our researcher, Dr. Chiara Redaelli, has classified and declassified a number of situations, or reclassified a number of situations. We can highlight in particular the situation in Afghanistan and also Mozambique. The result then of our research is accessible on a unique online portal that is called the RULAC database, Rule of Law in Armed Conflicts. And this is really a very useful tool. I hope you know it, I hope you use it, but many academics, practitioners, states, international organizations refer to this RULAC database when they want to identify very quickly what are the ongoing armed conflicts, how they are classified from an IHL perspective, and what is the applicable law. So we use open source information to conduct this classification, and we update the database really constantly. Which allows us to provide really fresh classification and also to keep our very high academic standards. Now, because we conduct such a thorough work on classification, we are each year faced with new specific situations. And this leads me to my third reason why it is worthwhile to have this conference on classification. Well, almost each new armed conflict gives rise to novel questions, doubts, interrogations regarding classification. Take, for instance, non-international armed conflicts. Well, from an IHL perspective, the basic criteria to determine the existence of an armed conflict seem quite clear. So for an IAC to exist, you need to have organization and intensity. So in other words, you need to be faced with a situation where the belligerent parties are clearly defined and the non-state party needs to be sufficiently organized. This is why we use the technical term of an organized armed group. So a loose criminal band or violent group may be able to project serious acts of violence, but this would not suffice to consider it as an organized armed group from an IHL perspective. Regarding intensity, the level of violence between two belligerent parties needs to be sufficiently high to give rise to a non-international armed conflict. If that is not the case, you are faced with what the ICRC would call an other situation of violence, OSV, i.e. a situation that is violent, but to which IHL norms would not apply. Now, when you confront these legal criteria with the reality on the ground, you realize how complex it can be to apply theoretical criteria to concrete situations. If you look at conflicts in Iraq, Syria, Mali, Nigeria, Yemen, you quickly notice that it is often very difficult to determine the boundaries of armed groups, to know who belongs to which group, to understand how the group functions, how it is structured, how it operates. And you can see that groups actually split and reunite very quickly, that they turn from allies to foes. Relationships between groups are also unclear. And then notions of cells, groups, networks, platforms, coalitions, umbrella organizations proliferate and add complexity to the classification of situations of violence. Brilliant IHL experts try to grasp this complexity and offer theoretical solutions to the complex reality we are faced with. For instance, we can notice a nascent trend in the literature to try to aggregate intensity that is projected by various armed groups in order to construe the level of intensity that is required to reach an armed conflict. These pragmatic theories may facilitate the classification, but at the same time, they give rise to a risk to overclassify situations of violence, i.e. to consider that IHL applies to situations that are technically OSVs. So since we are confronted with these issues at the Geneva Academy on a daily basis, and since there are no ideal or easy solutions to complex situations like this, we want to share our doubts with IHL experts to confront ideas in order to offer the best possible classification of ongoing and future situations of violence. Talking about now the future and future situations of violence leads me to a second example of complex situations that exist and that will increase in future wars. We live in an era where digitalization is omnipresent. I mean, look at us today. And so in the future, wars will increasingly be fought in the digital space, and new military technologies are set to revolutionize the ways wars are fought. Cyber warfare, especially between highly developed countries, is a spectrum that may be frightening and that will give rise to new humanitarian protection needs, especially when cyber warfare is being combined with other new technologies such as artificial intelligence. Albeit very important work has already been conducted around cyber warfare, notably through the Tallinn expert process and manual, states disagree on many core issues that relate to cyber warfare. Even the extent to which IHL rules would apply to cyber warfare remains debated. And even among experts agreeing on the basics, i.e. that IHL applies to cyber warfare, even among them, debates remain. So, for instance, what can be considered a cyber attack? Or what would be considered as a civilian object in this context. So these are numerous challenges, and when it comes to cyber warfare, and those challenges obviously also appear in relation to classification issues. So here again, having the opportunity to share ideas, to anticipate potential issues is essential to stand ready and to offer the best possible protection to individuals. You will have noted that the two examples I have just mentioned, i.e. the issue of aggregated violence and cyber conflicts, are the two topics we have selected for discussion this year. So I'm delighted that we have with us today a range of top-notch experts to address these issues, and I'm very much looking forward to our discussions. Now, without further delay, I give the floor to Ms. Emily Max, who is a researcher at the Geneva Academy and who will present the panelists of the first session on aggregating violence, Quo Vadis. I thank you very much for your attention. Emily, you have the floor.
Thank you so much, Gloria, for this very comprehensive introduction. And hello to everybody. Thank you for joining this conference, and thank you to Chiara and Gloria for inviting me to chair the first panel of this afternoon discussion. Before presenting our distinguished panelists, just a few words on logistics and housekeeping. You will have noticed that you participants do not have access to the microphone or the camera features. However, you are highly encouraged to ask questions or challenge our panelists' views in the chat feature. We will take questions in a first-come, first-served basis, and if some of them address similar issues, I might group them in cluster of questions. And then we will discuss them during the Q&A part of the discussion, roughly the second half of this first panel. So now, without further ado, I'd like to introduce our distinguished panelists. So first, we have our very own Dr. Anissa Belal, who is a senior researcher and strategic advisor on international humanitarian law at the Geneva Academy. We also have today with us Thomas de Saint-Maurice, who is the head of unit of legal advisors to the operations at the ICRC in Geneva. We also have Professor Jan Kleffner from the Swedish Defense University. And last but not least, we have our very own Pavle Kilibarda, who is a teaching assistant with us at the Academy and also a PhD candidate at the University of Geneva. They will each give their presentation in the order I just presented them. And each of them will have about 15 minutes to do so. I very much look forward to the discussion on this important yet still debated topic. And without further ado, I will start with giving the floor to you, Anissa.
Thank you very much, Emily. Thank you also for the very kind introduction. And I would like also to thank the Geneva Academy for inviting me to speak about this fascinating topic. And I see it's quite fascinating because when there are more than 160 persons attending this event, it means that it's a very successful topic indeed. So that's very nice. I will indeed focus my remark on the issue of coalitions as introduced by Professor Gajoli. And indeed, as we know, there is an increase of states, but also armed groups coalitions. And this is a striking feature of contemporary armed conflicts. This also raises different legal, but also operational challenges, and I will try to address some of these in my few words. First of all, just a few numbers about state coalitions. I know we are speaking more about armed groups ones, but I thought it was interesting also to think back about a few numbers on state coalitions and how they are becoming more and more important. So in 2003, the Uppsala Conflict Data Program noted that out of the 27 non-international armed conflicts that were occurring in 2003, only one involved a foreign state in the coalition. So it was less than 4%. And 10 years later, the same program noted that 27% 40% of non-international armed conflicts involve foreign state support. And in 2017, 40% of NIACs could be characterized by the involvement of foreign state. So you can see that there is a sheer increase of state coalitions in contemporary armed conflicts, and this also raises legal issues, as was addressed by the ICRC, notably through the support-based theory, which we are not going to talk about today. And it would be quite interesting, actually, to number to find some statistics about the increasing number of armed groups coalitions. So it is true that when we look at the different conflicts today, there are a high number of armed groups operating in different conflicts, such as in Libya, Syria, or in the Sahel region. And what is happening is not only these groups are indeed fighting at an individual level, but they are also fighting and forming coalitions to form common enemy, to fight against a common enemy. And I think one of the interesting examples of this kind of coalitions is what is happening in Mali. In fact, in Mali, you have several coalitions of armed groups. So you have the JNIM, which is the Jamaat Nusran al-Islam wal-Muslimin, which is a coalition. Also, please allow me to be cautious about the term coalition. I will come back to that. So it's a, let's say it's a coalition of different Islamist armed actors in the region. But you also have the CMA, and here the name, actually, Coalition of the Movement of Azawad, was the name proper of this coalition, and it is formed by 3 Tuareg armed groups, which are fighting in support, normally in support of the government. So what are the challenges from a legal but also from an operational point of view, which are raised by these coalitions of armed groups, again here in bracket? So to my mind, there is one key question to ask. The question which I think is worth focusing on is, what are the linkages, or what are the relationships that must exist between non-state armed groups in order to consider them as a single party to a conflict, including across borders? Or in other terms, when can we consider that a coalition of armed groups exists? So to be fair, there is not, there's not so much information either in the text of the conventions or in case law about what kind of relations should or must exist between different armed groups so as to be able to consider them as one single party to a conflict. Similarly, the 2016 ICRC commentary does not address the issue. So establishing the relationship between armed groups is of particular importance with regard to the territorial scope of application of IHL. And it also brings to the fore the more basic question of how to delineate armed groups for the purpose of classifying non-international armed conflicts and applying IHL, as well as with regard to the end of the application of IHL, so the end of the NIAC with armed groups and their different factions. So, for instance, and to give a bit more, concrete aspect to this question, coming back to Mali, could we consider that the MNLA, which is one group of the coalition of the CMA, so the MNLA, which is the Mouvement National de Libération de l'Azawad, and this group has signed the peace treaty with the government, and it does not, as of today, engage anymore in hostilities. But can we consider that this MNLA is still a party to the armed conflict because it belongs to the coalition, so the CMA, which controls territory and fights against other armed groups? So that is one question that we had to deal with in a coalition. Which member of this coalition is still involved in the armed conflict or not? And another legal question that we could ask is, when it comes to the applicability of Additional Protocol 2, would it be sufficient to have one group of the coalition controlling territory, and it would then apply to all the other groups belonging to the coalition, or even if they do not control territory, or should it remain an individual assessment? So these are some very concrete, legal questions that one can ask when it looks into coalition of armed groups and the applicability of IHL. The notion of coalitions of armed groups have been expressly addressed by the US in its doctrine of associated forces. So according to the United States, when armed groups support or associate themselves to Al-Qaeda, such as in its view Al-Shabaab in Somalia or ACAP in Yemen, they automatically become a new party to the NIAC, already opposing the US themselves and Al-Qaeda. So as a result, the hostilities between the US and these associated forces do not need to reach any separate intensity threshold to trigger a new NIAC and to make members of those forces targetable at any time. But this doctrine, at least in my view, is problematic in two main respects. Firstly, the support considered under this doctrine is not precisely defined and may possibly include very indirect support, which would extend too much the applicability of IHL. Secondly, it relies on an analogy with the concept of co-belligerency. So in other words, it would mean that the supporting armed group becomes a co-belligerent with Al-Qaeda because of its support. And scholarship has devised a number of theories to delineate the boundaries of organized armed groups. For instance, some authors argued in favor of applying the notion of co-belligerency, as I just explained, to non-state armed groups in NIAC. Others have proposed to apply by analogy the notion of associated forces as present in Article 51 of AP1 and Article 4 of GC3 to devise the relationship between armed groups, notably for the purpose of targeting. And these proposals were met with some criticism, usually because they lack either firm basis in law, either in treaty or customary international law, or because the application of the law and concepts from the law relating to international armed conflicts to NIAC in these particular cases were thought to be inadequate. It was also suggested that an aspiring faction would belong to an armed group if it falls under the command and direction of that group. So in a recent blog, which I'm sure that my distinguished colleagues from the ICRC will speak about, a blog which was published by the ICRC legal team, give some example of criteria that could help us to assess whether there is a sufficient level of coordination could be present. So for example, the criteria could be the establishment of a centralized joint command, allocation of areas of responsibilities, sharing of operational tasks, such as, with regard to detention, procurement, equipment, transport of troops, so on and so forth. Exchanges of tactical information, existence of an umbrella platform, or exchanges of communication in the name of the members of the coalition. So these are the examples that are given in the blog. When you look at this example, one feeling is that these are of a quite sophisticated, let's say, procedures to give some indication of how an armed group could be coordinated. It's a high level of coordination, which is implied here. And it did also add in the blog that a shared ideology or similarities of political views or the mere existence of a common enemy would not constitute sufficient grounds for concluding that the different parties are fighting under the framework of a coalition. And I understand, obviously, that this is a proposal, and the main objective of the discussion was to ensure that the adequate legal framework, which reflects realities on the ground, applies to the situation. Be that as it may, and how interesting are these proposals, I think it is also essential to look at the practice of armed groups themselves on this issue, although the practice is quite scarce. But we can give an example that in 2014, at the peak of its power, the Islamic State armed group claimed that some of the groups that pledged allegiance would not be accepted until they maintained a direct line of communication to al-Baghdadi and until he appointed or formally recognized the group's leadership. So while I can agree in some circumstances with the proposal that armed groups with a common command and structure should be considered as one entity, the problem is that the structure of armed groups is often opaque, and may evolve rapidly. So it's often quite difficult to have a comprehensive understanding of the structure and organization levels of various actors, their involvement in the armed confrontation, or the relationship between them. So in these circumstances, absent clear legal basis and case law, I would tend to be of the opinion that in most cases, the better solution might be to establish for each group whether the requisite threshold of organization and intensity of violence have been met, and whether individually each group is party to an IAC or not. And this is the approach that was taken in the war report, in the successive war report, which were published by the Geneva Academy until 2018, in fact, when assessing the existence of non-international armed conflicts. This is, of course, open to debate, and I do look forward to hear your views about that. So thank you for your attention.
Thank you so much, Anissa. Now I'd like to give the floor to our next speaker, Thomas de Saint-Maurice.
Thank you very much, Emily. Thank you for the Geneva Academy for the invitation. It's really a pleasure for me to be here and share a panel with you all. My usual caveat: not everything I will say today is necessarily the institutional position of the ICRC, though of course I will rely on ICRC positions, and I will tell about the current status of our reflections. And actually, we are very glad to have a legal debate on such kind of issues, which are objectively raising operational challenges to us all. So institutional positions of the ICRC on the matter of classification can be found in official publications such as the Challenges Report that we publish every 4 years, the last one in 2019, and of course also in the updated commentaries to the Geneva Conventions, and in particular for classification issues, common articles 1 and 2 and 3. So indeed, among the challenge that we face in terms of classifications is the constant increase in the number of armed groups operating in conflict areas. Now, if we take the figures of the ICRC, we have legally classified as such more than 80 non-international armed conflicts today, involving more than 100 non-state armed groups, parties to those conflicts, and we think that around 1/3 of such non-international armed conflicts involve some sort of coalition, really loosely defined, meaning that at least on one side there is more than one party fighting together. And these figures actually have increased constantly over the past 15 years. And in particular, if we look at non-state armed groups, we see them, as said by Gloria, multiplying, splintering, but also forging alliances, etc. So I will not summarize again the classical criteria for classifications of conflict. Gloria did that extremely well. I will dive directly into the details of the approach we suggest for dealing with coalitions of armed group in a very specific scenario, by the way, that I will explain. What the ICRC stated officially in the 2019 Challenges Report is that, and here I will quote, when several organized armed groups display a form of coordination and cooperation, it might be more realistic to examine the intensity criterion collectively by considering the sum of the military actions carried out by all of them fighting together. So what we have tried to do 1 year later with my colleagues, Jelena Nikolic and Tristan Ferraro, is to develop a little bit more what that means, this approach. In this blog post you referred to, Anissa, and this is what I will develop a little bit more now. I will try at the end to maybe just give an illustration to that approach. We'll take the example of the Central African Republic. Actually, just 2 months after we published the blog, the situation of violence deteriorated in this country, and what happened there was actually, or could be actually, a good illustration of why such an approach makes sense. So, the criteria to classify a non-international armed conflict are organization of the parties and intensity of armed confrontation between them. It is extremely important that we preserve these criteria. In addition, we use generally what most of us call a fragmented approach to legal classifications of situations of violence. And indeed, we do that because it is important to isolate the bilateral relationships of belligerents that exist in a situation, as well as the specific entities parties to the armed conflict, whether states or non-states. And it's important to keep that also in the background when we do classifications and when we suggest a classification approach, however pragmatic they may be. Indeed, we also think it is important to keep in the back of our mind that human rights law is the default legal framework applicable for state use of force when they deal with violence which have not reached the required level of intensity and or against groups which have not the required level of organization. And I submit that the approach that we propose preserves all of these principles, if we want to call them that. So in situations where we see that several armed groups seem to work together in what could potentially be an armed conflict, what we propose is to zoom out a little bit instead of isolating each group's acts. So we zoom out a bit, but not to a point which would allow to conclude that there will be an armed conflict in a country just because there is a general level of violence which is high, and without identifying exactly who is who. In particular, who is a party to a conflict and to which conflict. So in a nutshell, we somehow propose to aggregate the intensity of the armed confrontation in one relationship of belligerents between one side against another side, but there is on one side at least several parties composing that side, because they have adopted a collective approach to the fighting against their common enemy in this single armed conflict. So to say it simply, there are many cases where parties act in a form of coalition. The term is there, and this is a precise scenario we want to address using as much as possible, using the classic criteria for classifications. So what are the conditions we suggest to adopt for this approach? First, and it is extremely important to remind that we need to assess the organization of the potential parties to this conflict, because in our view, we cannot get rid of a thorough analysis of the criteria of organization. It is a critical element and the condition to use our approach. And assessing the organization of the group involved in the violence is sometimes very, very challenging because nowadays they can be very volatile. They can have different types of structures, they fragment, they splitter, etc., etc. And I'm afraid our approach does not address this challenge at all. So we are talking about something different. We have to analyze the organization for all potential parties. So if a group involved in act of violence in a potential conflict is not organized enough for IHL purposes, then it is excluded from the analysis and cannot be counted as a party to the conflict, and the violence involving this group will not be regulated by IHL. So that's a starting point that is important. We start with the identification of organized armed groups. Then we will look at the relationship between them on the same side. how they work together, how they coordinate the actions, support each other, etc. When we consider we have elements demonstrating that several organized armed groups have put in place a sufficient level of coordination, that they act in some sort of a coalition to fight their common enemy in a particular belligerent relationship, then we can look at the criteria of intensity by aggregating the armed confrontations occurring between these groups together and their common enemy. These armed confrontations, by the way, involve either several organized armed groups in their own capacity, I mean, as part of the coalition, but sometimes they do just joint operations, for instance, as part of the coalition. For the enemy, if you take the point of view of the enemy, in fact, for operational purposes, it makes no real difference what are the precise affiliations of the fighters attacking them, as long as they carry out military operations in a coordinated manner, and as long as they are members of organized armed groups, part of this coalition. So, in a way, to apply a strict approach requiring to assess separately the relations of belligerents between each and every party of the coalition would mean taking the risk to not be able to conclude intensity has been reached for any of the groups separately, and therefore taking the risk of putting the reality on the ground and the legal analysis at odds. In preparation of today, I read something that summarizes quite well what I think about that particular types of scenario, and it is from a paper written by Vaios Koutroulis in the Bruges Colloquium proceedings. He says, and I quote him here, if we restrict the scope of armed conflict too much, then we end up with a utopian definition that will not be followed because it will be in contradiction with the facts on the ground. And I think this is really the balance that we have to find, the adequation with facts on the ground and the fact that it's connected. So we need to reserve the application of IHL to extreme situations of armed conflict that are armed conflict. And we also acknowledge the fact that when the facts tell us we are facing such an extreme situation, it will be unrealistic to expect government forces. And by the way, a fortiori, even less if the common enemy is not a state, but a non-state armed group, to respond to the intense armed confrontation against several organized armed groups, which are fighting together only with law enforcement means. Just because legally speaking, we have to isolate facts of each groups and separate them to analyze them to determine the legal framework. On the ground, acts are not dissociated. And the law enforcement paradigm, therefore, would most certainly not be adapted for that specific type of scenario. So we suggest to aggregate intensity when organized armed groups fight together in the same conflict against a common enemy. So the difficulty here is also to establish somehow the existence of such a coalition, demonstrating a sufficient level of coordination. And it's true, there is no definition of the notion of coalition in law. So like for other concepts, we are quite used to that under IHL. We suggest to rely on some factual indicators that could show this level of coordination. Some of them have been mentioned by Anissa. They are just there for debate. I mean, that there are factors that could be used in order to find out whether there is this sufficient level of coordination between the groups to establish there is a form of coalition that will allow us to use our approach. So these factual indicators, notably to see how they share areas of responsibility or areas of operations, how they conduct joint operations, maybe how they support each other, maybe by logistics, procurement, equipment, other things, how they share intelligence, whether there is an umbrella platform, etc. So some tangible and convincing facts must be there. And indeed, as said by Anissa, we will consider that sharing the same political objectives or the same ideology will not be enough, or just the fact of fighting a common enemy would not be enough either. So we need to have the elements to demonstrate that they fight in the same conflict all together on one side. So if we use the illustration of the Central African Republic, end of 2020 and beginning of 21. So you might remember mid-December 2020, several armed groups issued a statement declaring that they decided to join a new movement, which was called the Coalition des Patriotes pour le Changement, CPC. And the declaration actually goes even further because it mentions merge of groups, unified command, etc. So if we use our approach to that situation, a new situation of violence emerging, is that sufficient, this statement, to consider all signatories as potential parties to the same conflict by aggregating all the acts starting from mid-December to assess intensity? No. In this kind of situation, we will have to analyze first, and that was mentioned also before by Anissa, whether or not this CPC, this new coalition, is actually not a new organized armed group itself, by effectively merging, absorbing pre-existing armed groups that were maybe independent from each other. So I will not extend on that, but it's a different scenario because here it's not a mere coalition, it's a new armed group with a new command and control structure where we have only one armed group in the end. So that's something else. And by the way, Vaios Koutroulis, I mentioned just before, in this Bruges proceedings, mentioned this in his writing, so you can have a look to that. So the coalition approach is for situations that actually fall just short of that, short of the creation of a new single organized armed groups. In the case of the CPC, it may well be that indeed the organized armed groups members of the coalition have kept their independence and their own command and control structures, but still they fight together, and they marshal the means to fight a common enemy in a conflict. So according to our coalition approach, first we need to assess the level of organizations of all armed groups, potential parties to the armed conflict. And again, it may well be that some groups, members of the coalition, of the CPC in that case, do not meet the criteria of organization to be a party to a conflict according to IHL. And then we need to assess whether there is a sufficient level of coordination between the organized armed groups, members of the CPC, beyond the word of the statement. And some groups may actually, in fact, not take part to the coalition, contrary to what the statement would make us believe. So that's the complexity of the thing and the narrow scenario or the frame we give to this approach. What happened on the ground in Central African Republic, end of December 2020? Attacks were carried out in a coordinated manner by several organized armed groups, members of the CPC, first in the west, in the northwest, in the southwest, and then later on in the center, and then a few days later in the southeast. Different groups there operated in their own area of influence, but sometimes also together in joint operations. And they organized themselves, they coordinated their military operations to have the maximum effect on the Central African forces. And then the common objective of the coalition was to take Bangui together, the capital of the country, which they attacked visibly in a coordinated way. But very clearly between mid-December and January, if you had to analyze the armed confrontations for each armed groups separately, then you might not have a sufficient level of intensity for each of them. And then you have no other choice to conclude that IHL is not applicable to that kind of situations. And what happened is not an armed conflict, or becomes an armed conflict, but later on. While in the field, it seems obvious from the facts that the state could not deal with the situation with law enforcement means, because it had to face this joint coordinated acts of violence from different groups. Taken all together, the armed confrontations carried out by the organized members of the coalition on the contrary, would or may have met the threshold of intensity. So, in conclusion, I would say that the approach we propose is quite strict, quite demanding in the analysis that is required, but also providing a solution which is sound in fact and in law and addressing concrete situations we are dealing with in contemporary armed conflicts. Well, I hope I was not too long. Thanks for listening. Floor back to you.
Thank you so much, Thomas, and thank you for highlighting the need to reconcile what is a very technical and demanding analysis, as you said, from the law, with actually the impact that the conclusions of this analysis might have on the ground, and making sure that the law fits the reality as much as possible, even if smaller gaps remain. Now I'd like to give the floor to Professor Kleffner to hear his views on aggregating violence.
Well, thank you, Emily, and thank you to the Geneva Academy for inviting me. It's a great pleasure to join you all. We are, of course, facing an issue of immense complexity. So forgive me if I'm probably not shedding much more clarity to it, but just add some more confusion. My fellow panelists have already alluded to the issue before us. It's really the reality of situations of violence in which we see multiple armed groups and governmental armed forces involved. And the question really is whether the requisite level of intensity for an NIACs to exist has to be assessed on a bilateral basis, that is between two opposing parties, or whether the intensity of violence can, at least under certain circumstances, be accumulated or aggregated. And we have already heard a number of factual scenarios, but I just want to add maybe Syria, the DRC, and Libya as pertinent examples, where several organized armed groups fight against governmental authorities and against each other, or they confront a common enemy, but operate independently and individually, or indeed they forge the alliances that both Anissa and Thomas alluded to, oftentimes, of course, fragile ones that later collapse. However, I would like to shift our attention somewhat away from the issue of coalitions. If you'd allow me, the issue that I will primarily address is whether the requisite level of intensity can be met cumulatively by the actions of more than one organized armed group that act independently against governmental authorities or against each other, even though the actions of each one of them in their respective bilateral relations, taken in isolation, that is, do not reach the requisite level of intensity for an act to come into existence. So if one were to require intensity in the bilateral relations between Armed Force A and Armed Force B, Armed Force A and Armed Force C, Armed Force B and Armed Force C, and so on, it would mean that several NIACs may come into existence at different points in time. In contrast, a cumulative or aggregated approach to assessing intensity would mean that a single non-international armed conflict begins once the requisite level of intensity of the violence caused by all armed forces. And it's interesting to see that at least some of the international courts and tribunals had to deal with such situations, not the least the ICRC as regards Eastern DRC, the Democratic Republic of Congo. And that obviously being maybe a situation at the extreme end of complexity regarding actors, where at times reports have indicated that we're about 70 armed groups, 70 that is, armed groups being involved or having been active. And here the ICRC is in a way, the ICC is in a way reflecting our debate, because different trial chambers have taken different approaches to the Eastern DRC. The trial chamber in Lubanga, for instance, suggesting a bilateral approach, whereas a different trial chamber in Katanga seems to allude to some sort of aggregation type of approach. We've heard that the ICRC also, and this time it is the ICRC, not the ICC, takes a similar approach in complex situations. And we just heard also Thomas explaining the approach in the specific instance of coalitions between armed groups. I will return to that in a few moments. However, it might be useful to note that the more global, cumulative or aggregated approach to intensity has also been echoed in the practice of some bodies in relation to Syria, and also in some legal scholarship that addressed the questions of whether and when the NIAC had come into existence in Syria. Now, before causing any misunderstandings, I'm in no way suggesting that the limited case law that we have, doctrine and some practice, has brought any clarity to the debate. However, I would like to share with you my reasons why I think that there's merit to aggregating intensity under certain conditions in complex situations such as ones in Eastern DRC or Syria. Now, where a situation of violence in a given area during a given period is characterized by a high fluctuation in the number and strength of organized armed groups, including shifting alliances, maybe, but sometimes even not that, maybe hastily assembled coalitions and their breakup, I would submit that a bilateral approach to intensity runs the risk of defeating the purpose of the law of armed conflict, IHL, and that is to ensure proper balance between humanitarian concerns and considerations of military necessity. As we all know, the law is fact-driven and designed to apply only in situations that involve the requisite level of violence, but the necessity, both in military and in humanitarian terms, for the law of armed conflict to govern a given situation does, in my view, not depend on the question of whether the violence between two parties in their bilateral relationship reaches the required threshold, or whether that violence occurs between several opposing parties in their mutual relations. So if the accumulation, the aggregation of death and injury and destruction caused by several organized armed groups and governmental authorities is such that it can reasonably be said to be sufficiently intense as required under the law for NIAC to exist, in my view, victims in that situation should not be deprived of the protection accorded by IHL for mere reason of the fact that the violence that characterizes the bilateral relations between any two of its authors stays below the requisite level of intensity. And of course, as a flip side to the coin, I would also suggest that parties to such a situation should not be deprived of the rights of privileges and authorizations that the law of armed conflict provides to allow them to submit their opponents. Now, the problematic consequence of bilateralizing intensity would be that sporadic acts of violence or other situations of violence by one organized armed group, let's say party A, against another organized armed group or governmental authority, party B, which is also involved in a pre-existing non-international armed conflict against the third organized armed group or governmental authority, party C, in the same geographical area and during the same period, would still fall outside the ambit of the law of non-international armed conflict. And that would, of course, give rise to a significant regulatory void, not the least against the background of the continuous debate that we face as far as the applicability of human rights law to organized armed groups is concerned. Now, in addition, to bilateralize intensity in such a situation would also entail that the disappearance of the requisite level of violence in the bilateral relations between party B and party C in this case could entail that the naic between the two comes to an end, whereas the coexisting, and then again in geographical and temporal terms, coexisting bilateral non-international armed conflict between either party and a fourth party, party D, then continues for as long as that requisite level of intensity is reached in their bilateral relations. So we have a situation that looks from the outside overall as a non-international armed conflict, but we would isolate within that non-international armed conflict certain relations that are then not governed by the law of non-international armed conflict. And I would therefore submit that aggregating intensity may, in certain situations, be a matter of humanitarian and military necessity. I hasten to add, though, that such an approach obviously entails significant risks if applied routinely to all situations of violence in which organized armed groups are involved. And actually, taken to its extreme, it would amount or would give credit to the theory of the notion of a global war on terror, where we have maybe one, maybe several organized armed groups acting sporadically, and we add on intensity, and in one way or another reach that supposed non-international armed conflict on a global scale. And it should be very clear that I'm not advocating for such an approach, where clearly distinct terrorist acts, separable in temporal and geographic terms, were lumped together and elevated to an armed conflict to then justify responses within the conduct of a paradigm rather than a law enforcement paradigm. So in that sense, I think I fully share the concerns that Anissa already alluded to, and Thomas also made a similar point. So what I'm suggesting is that is actually, in order to avoid the risk of over-application, is to use a corrective, which is that only in situations, in complex situations, where acts of violence by several organized armed groups occur on a geographical and temporal continuum, shall one allow for aggregating intensity or aggregating violence to meet the requisite level of intensity. So that continuum, the geographical and temporal continuum, serves the purpose of distinguishing acts of violence that are reasonably grouped together because they occur in an identifiable area and within sufficient temporal proximity of one another, and distinguish those from a loose series of acts of violence by different organized armed groups that occur over clearly separable geographical areas, perhaps even in non-adjacent states. Now, everyone will then probably ask, what does it mean, a geographical and temporal continuum? And I cannot be more precise than saying that, in my view, the exact contours of what is the area concerned, what is the time frame concerned, is certainly context specific. But just to give you one example, which I think is reasonable, and that's the example of the ICRC trial chamber in Katanga, where it looked into Eastern Congo and more specifically the territory of Ituri to make the assessment, and it looked into the specific period from January 2002 to May 2003. So that's maybe indicative of a possible approach. However, I would be the first one to admit that the legitimacy of this suggested approach that allows for aggregated intensity will depend on a good faith application, and that good faith application really would need to center around the exigencies of the factual situation as requiring the application of the law of non-international armed conflict. Now, this geographical and temporal continuum corrective is also what distinguishes the ICRC's approach to intensity aggregation from which one may dub the coalition approach from the approach that I'm suggesting. In my view, examples such as Libya or Syria or the Sahel amply illustrate one of the major conundrums of the coalition approach, namely that coalitions between organized armed groups are rarely static or stable. And indeed, organized armed groups may be coalition partners one day in a joint effort to weaken a common opponent and fight that common adversary and each other on the next. So one of the implications would be that intensity could fall back below the required threshold, despite the fact that its total sum has not decreased. So indeed, it may have increased because of the additional fighting that occurs between the former coalition partners. And another complexity consists of situations in which one coalition partner breaks up, not uncommon, with one part of such an organized armed group continuing to act as a coalition partner, whereas the other part continues to fight on its own against that common adversary, whereas both the continuous coalition partner and the newly independent organized armed group generate violence that, if aggregated with one another's and that of the other coalition partner, remains the same. And it would seem to me that these two scenarios demonstrate that the requirement of coalition for accumulating intensity bears the risk of refragmentation, if you will, or re-bilateralization. And by that, end up in a revolving door scenario, despite the fact that the situation on the ground, and with it, I would suggest the need for applying IHL, has not changed, or as far as the overall intensity is concerned. And secondly, and finally, I wonder, and this is a genuine question, it's not a rhetorical question, I wonder what results the coalition approach produces in situations where two or more organized armed groups act in a concerted or coordinated manner against a common adversary, but do so without the temporal or geographical continuum that I would suggest as a correct. Let us assume that two organized armed groups launch an attack on a military base of a state in state A, and coordinate that attack with another organized armed group's attack against the same state's military bases in state B. Would there not be a risk that one may have to conclude that a non-international armed conflict has come into existence under the coalition approach, provided, of course, that we consider the two attacks together to actually reach the intensity threshold? So in other words, would there not be a risk under the coalition approach that we are going back to this kind of Nadelstich theory that characterized the over-application in connection to the global war on terror, to which the ICRC, I am fully aware, is certainly not very positive, nor am I. And I just wonder whether the coalition approach would nevertheless, without the necessary correctives, actually allow for such an over-application. I've gone over time, I apologize for that, but maybe just leave it at these questions and observations, but not before thanking you for your attention. And I'm looking forward to our discussions.
Thank you, Professor Kleffner. And I think, your point on the approach and how to grasp or grapple with the war on terror is something that is going to come back during the Q&A, because we've had a few questions about that. With one small, sorry, I'll start again. For those of you who have asked questions in the chat, thank you so much for being so interactive. We've had a lot of questions already, so at this stage, I already want to make no promises that each of them will be addressed in the Q&A. That's that. And now, last but not least, I'd like to give the floor to Pavlik to hear his views on the topic and also on what the three others have said before.
Thank you very much, Emily, and thank you all for, it's a great pleasure being here today at the Geneva Academy with such distinguished co-panelists and such a high number of participants. It's absolutely wonderful to participate in this exchange. And if I do say so myself, I think that if anyone had felt that this matter, the matter of conflict classification, was sufficiently settled under contemporary IHL, then I think that my co-panelists today have shown otherwise. Now, you will see from my presentation that I'm not exactly favorable to either accumulating or aggregating intensity. I do take my hat off to both Professor Klappner and to Mr. de Saint-Maurice for arguing their approach in such a thought-provoking manner, but I am rather still not a believer in this approach. So I have many comments. I will try to limit them really to the main and most general ones that go to both theories, because we are in fact discussing two different theories. They have significant overlap between cumulated intensity argued by Professor Kleppner and aggregated intensity argued by Mr. de Saint-Maurice. But my criticism largely, I think, applies to both. Or rather, I shall not call it criticism. I would say it's rather concern. Now, my first thought is that, and this is something that both Professor Kleppner and Mr. de Saint-Maurice and the co-authors of Mr. de Saint-Maurice for the blog post are all aware of, is that we are asked to modify the sort of traditional approach to conflict classification. So I think that everyone agrees that and I fully concur with this, is that the textbook approach, what we teach our students, is to take different factions, different parties to an armed conflict, and then bilateralize their legal relationship. This is, I really like the term employed by Professor Robert Kolb, the faisceaux bilatéraux, the bilateral bundles. So a non-international armed conflict is basically a certain legal relationship between its parties. Obviously, this approach is not unchangeable. It is not scripture, but if we wish to modify this tradition, then I think we have to really find preponderant reasons to do so and to be absolutely convinced that the modification will not lead to desirable consequences. Now, sort of first remark, again, will be that both theories, in my view, don't really find much support in jurisprudence. And as we all know, and this is something that we keep repeating, is that jurisprudence is the main source regarding conflict classification. So if we take the ICC cases taken by Professor Kleppner, I think that there is indeed room to interpret them in this way, but I would still find that there are two caveats in this regard. So first, and I think that Professor Kleppner mentioned this himself, there is some ambiguity in the ICC's approach in Katanga. And then second of all, and this may come across as slightly cynical, but I think we do have to take the institutional perspective into consideration. So the ICC is, after all, a criminal tribunal, and in order to exercise its own mandate, it really needs to establish the existence of an armed conflict in order to be able to proceed with a war crimes prosecution. Now, in my view, already these two concerns cast doubt on the idea that accumulating or aggregating intensity enjoys support in international jurisprudence. A second general problem that I have with both theories is they somehow, we do consider, and you do consider actually in both of your theories, the necessity of balancing between military necessity and the requirement of using force under IHL, for example, which is oftentimes legitimate on the state's part, with the need for protection. But in your writings, you do very much highlight the protective and humanitarian reasons for facilitating conflict classification. And I fully admire this concern. I share it myself, but I'm not at all convinced that resort should in general be made to the IHL of NIACS for better protection. To the contrary, situations of armed conflict, including perhaps especially non-international armed conflicts, are exceptional circumstances warranting extreme measures not permissible in peacetime. For example, I think that most lawyers would agree that it is lawful to use force against fighters as a first, not last resort, as required by peacetime human rights law. In addition, there is the entire ongoing debate about the IHL framework regarding security detention in NIACS, which, in my view at least, seems more permissive than that of human rights law. Thus, to apply IHL means to de facto derogate from human rights law, and I frankly do not see how this could best serve the interests of the local population. Now, I understand absolutely the concern that armed groups may not be bound by human rights law, and that there is an additional interest to try and at least bind them through IHL. Now, Professor Kleppner, you wrote about this in your piece from 2019 on intensity and organization. that in the example you give, if there is a conflict between A and B, but not between A and C, all involved being sufficiently organized, then there could be a regulatory void if we bilateralize conflict classification. But respectfully, I disagree, because first of all, international human rights law does remain applicable throughout the state's territory, triggering as appropriate the state's due diligence obligations to protect individuals from unlawful violence. And second, and this is something I feel we somehow as international lawyers tend to neglect, is that the actions of organized armed groups, just like the actions of criminal gangs, are after all governed by domestic law at all times. They do not exist in a legal vacuum simply because the group is fighting against the government. A third general remark that I have is that both the theory presented by Professor Kleffner and by Mr. de Saint-Maurice somehow seek to improve conflict classification by refining the definitely imperfect tools that we currently have to classify NIACs. But I feel that by developing these sort of new tools, we are making this process, this classification exercise, maybe even more complicated. Now, there is, in my view, much that is not clear or certain in relation to either intensity or organization as currently used in conflict classification. And I think that somehow if we add to this now additional notions such as geographic or temporal continuum as advocated by Professor Kleffner, or identifying coalitions or cooperation or coordination according to Mr. de Saint-Maurice, I think this becomes a bit even more confusing. Now, especially turning to the approach of aggregated intensity, I know, Thomas, that you give a lot of factors. Some of them were recalled by Anissa during her presentation today. And I think that's all admirable and fine. But even after reading this several times, I still feel that I'm somehow in the dark as to how to ascertain the existence of a coalition, or at least a sufficient level of coordination and cooperation between different armed groups as would warrant accumulating the intensity of the violence they project. And we have, I think, very different factors that you point to. As mentioned before, for example, it could be a centralized joint command, an allocation of areas of responsibility, and the sharing of operational tasks. Now, in relation to these specifically, I would wonder, why should we consider such groups possessing such common aspects? Why should we analyze them as a coalition? Perhaps we should rather think whether they are in fact the same armed group. In this case, I wouldn't really have an issue because we don't have to develop new tools compared to what we already have for conflict classification. Furthermore, for some of the other factors that you give, such as conducting joint operations, you mentioned it now also for your Central African Republic example, or sharing information and strategy, should we really describe this as a coalition? Because obviously two armed groups could engage in relation to a single engagement and then maybe continue fighting afterwards against each other. We've seen this in history. We see this today in different countries and in different regions. So I am still not entirely convinced that even this sort of cooperation would necessitate aggregating the violence they project with the intensity analysis. So I think that the criteria of intensity and organization, to add in good measure, the way they were handled originally at the ICTY, already left too much room for interpretation. And I feel that now, instead of facilitating the classification exercise, we're replacing one imperfect classification tool with another. And now, listening to your presentations, again, I wonder, on a more practical level, you both give very interesting and fascinating examples, both in your writings and in your presentations, of different complex situations, such as the Eastern DRC, Syria, Libya, the Sahel region, and so on, the Central African Republic most recently. But in all fairness, and I'm asking if maybe this is something that could be addressed later in the Q&A, I don't think that for a majority of these situations, even by using the sort of traditional bilateral or fragmented approach, as you will, that we can establish the existence of multiple NIACs in these countries. So I'm still interested in seeing what would be the major difference that we could achieve by using aggregated or accumulated intensity, as opposed to using the tools that we currently have at our disposal. Now, when confronted with contemporary non-international armed conflicts, especially those with a counter-terrorist dimension, and I think that these are sometimes they look like a category unto itself. It can really be extremely difficult to have proper access to information regarding intensity or organization. So for both criteria. We often have to work under circumstances of imperfect knowledge, and it is natural that as IHL lawyers, we should feel the need to apply their own body of law by somehow relaxing the standards in light of difficult working conditions. But faced with imperfect knowledge, is it really justified to presume the existence of a non-international armed conflict rather than to presume that there is no non-international armed conflict and that IHL does not apply? And this leads me to my final general point, which is about overclassification. And this is a phenomenon which has been discussed since many years ago. And I like Professor Sassoli's definition that overclassifying a situation means describing situations as governed by IHL when they're not, in fact, governed by IHL. Now, IHL being more permissive than international human rights law, at least when it comes to non-international armed conflicts. I don't think this is very controversial. We can see how some states might have an interest in overclassifying situations of violence. Now, if states want to have more free rein to use force to contain a situation of violence, I think that can absolutely be a legitimate concern. But I'm not convinced that all of us at this panel have this as at least a primary concern when discussing cumulated or aggregated intensity. I feel somehow that humanitarian reasons and reasons of protection come up in the first place. So should we, as scholars, come up with arguments allowing states to do so? I don't think so. But I do fully agree, to the contrary, that there is a need to refine our approach to conflict classification, and not by making it easier to describe something as a non-international armed conflict, but to simply have greater certainty that when faced with a NIAC, we can tell it for what it is. After all, I understand our role as lawyers is to first identify a legally relevant situation and to draw a conclusion from that situation as to what body of law governs it. We do not, in principle, first take our own body of law that we want to apply, and then we wrap it around the situation and we look how we can fit it because we really want to apply this body of law. Somehow, to me, this looks like trying to square the circle. Now, I would like to just conclude this brief presentation by reiterating my view. I respectfully think that we should stick to the bilateral bundles and the sort of bilateral manner of classifying non-international armed conflicts rather than accumulating or aggregating intensity, perhaps at least for the time being, and that at any rate, we should not be too trigger happy to classify a non-international armed conflict. Thank you very much for your attention.
Thank you so much, Pavle, for what was a very clear presentation, and also for reminding that, each person or stakeholder undertaking a classification exercise, being a scholar or an institution, actually has an institutional perspective that inform the exercise, and that it's also something that we should consider when determining whether the approach that is proposed is actually adequate or not, because classification exercises are never done in a vacuum. So now, if I'm correct with the time, we have about 25 minutes left for the Q&A. I will ask you to bear with me while I go through the questions, because we've had many, some of them addressed to some of our speakers and other, more general. The first one I'd like to ask our panel, sorry, I'm going, is one by Dominique Gassauer, and let me just find it. So, do you think that there's a possible scenario where violence is committed by two non-state armed groups as part of a coalition, but that these groups are in different countries, and that the level of violence meet the NIAC threshold? So basically, can you just comment on the geographical scope of classification? We've touched upon that already, but maybe if some of you would like to come back on it. Anyone?
Okay. I may give it a try.
Okay.
But bear with me. Our approach was not really developed with this specific scenario in mind. And I'm not sure that if we go beyond cross-border and spillover. It's a real life scenario, and the example of different branches or franchises of Al Qaeda have been mentioned earlier, and we certainly do not consider this kind of cases as realistically an illustration of armed groups fighting together in some sort of coalition. So we had in mind a situation of violence taking place in one country, a conflict taking place in one country involving local actors, if I may say so. But of course, we can discuss the cases of spillover in adjacent border areas, and you may know that the ICRC considers that the continuation of IHL applicability when there is an armed conflict taking place in one country, but there is a continuation of the hostilities across the border sometimes, and therefore we find that it will be it will make sense to continue to apply IHL in that situation. So it might be a prism of analysis of this, maybe the case that the person who asked the question had in mind, but I don't want to develop too much on that. This is not what we had in mind with our approach.
Thanks. Anyone else would like to jump in? No? Okay. Then I'll turn to the next question. And actually, I'd like to hear Anissa's and Jan's views on it. It's a question, let me find it again, by Sophie. And it's about counterterrorism, IHL, and classification. So what do you think that city concerns actually have an influence on the classification of conflicts? Maybe Pavle can speak about overclassification also at some point. And the example that Sophie gives is when a group is said to be associated with the ideology of another group designated as terrorists, do states' reactions show that in this case, the group is classified as a belligerent party? And does the ideological association make a classification more likely in that case? Especially, and the question is referring to states with strict counterterrorism legislation like the US, obviously. So maybe we can start with Anissa and then Jan, if that's all right, and Pavle.
Well, I'm not sure I understood entirely the whole question when one focuses on classification. I mean, from if we are talking about the topic of today, so I could say two things. First of all, is that not every acts which can be considered as terrorist acts, have or can be classified as an armed conflict. So, for example, we again, just to speak about the war report, because this is when I had the occasion to look at these things. The idea was that when you have unilateral acts that are sporadic or that do not necessarily involve combat with the state armed forces, this could not be classified as an armed conflict under IHL, but had to be addressed from a law enforcement point of view. So that's for the classification issue. And then, and perhaps also to allude to the question that was raised before, that was the argument made by the US, that if you had, let's say, so-called terrorist organizations such as Al Qaeda, and you had link between Al Shabaab and Al Qaeda, then they would be co-belligerent, just for the ideological point of view. And therefore, because they would be considered as being co-belligerent, the mere fact that there would be such kind of loose relationship between these two groups would mean that the US would be in the same armed conflict between Al Qaeda and Al Shabaab in another country. And this is, as Thomas has said, it's not at all something that the ICRC shares. And if I understood him correctly, and this is something also that at a scholarly point of view, it's not really shared either. so this is what I can say about, let's say, classification and counterterrorism issues. So if I understood the question correctly.
Thank you. Jan, do you also want to comment?
Well, I don't have much to add, maybe at least not beyond reminding ourselves that I think the notion of counterterrorism is more often than not helpful at all in the present context for a very simple reason, namely that states who are involved in confrontations of sorts with an organized armed group tend to rely on counterterrorism measures, language, rhetoric in order to do so. And that is completely disconnected from the question of is the intensity or is the group organized for purposes of classification. So I think it probably, I mean, the problem of overlap between counterterrorism operations and armed conflicts probably permeate each and every situation of armed violence in which an organized armed group is concerned, because the territorial state will always be classifying that organized armed group as a terrorist organization, either under domestic law or maybe sometimes also relying on the international framework of counterterrorism. But again, I mean, we're talking about really two separate kettle of fish, as it were.
Thanks. No, and I think the reminder that, you know, violence and organization are the two goalposts we need to continue working with. Pavle, I see you nodding your head. Do you want to add anything?
Just very briefly, maybe a few points that I don't think have been raised so far in relation to NIAC classification and counterterrorism. Now, obviously, as said by the co-panelists, the fact that the group is considered as a terrorist group doesn't really say anything about whether it's an armed group or not. So this is a separate issue. It doesn't really figure in the classification exercise. We don't ask ourselves, okay, are they terrorists? And then draw a conclusion from that. But there is a sort of then practice if you look at it in literature. So let's say 9/11 was somehow watershed in the way we tend to think about terrorist groups in the context of armed conflicts, regardless of the criteria of conflict classification. If you look at doctrine before 9/11, and terrorism is not a recent phenomenon by any means, you will see that legal doctrine and state practice really tends to think about it almost exclusively as a law enforcement issue. So it's something to be governed by domestic law, by human rights law, to be handled by the police, not by the armed forces. Since 9/11, for a combination of factors, which really I don't think I need to reproduce here, we are not exactly eager, well, at least not all of us. There are some scholars out there who actually say, well, counterterrorism, at least international counterterrorist operations, should be governed by the conduct of hostilities paradigm rather than law enforcement. They should be governed by IHL and not by human rights law. I mean, I disagree with this, and I think that all of the panelists here also disagree with this. Now, the thing is, okay, absolutely, an organized armed group can be described as a terrorist group for a number of I mean, this also, we have some guidance at the international level, but labeling someone or something as a terrorist is always problematic, bearing in mind the general lack of definitions provided under international law. And of course, terrorist groups can also function as organized armed groups, but these are two separate issues. Now, if we look at the work of political scientists dealing with terrorist groups, now by and large, many of these terrorist groups actually are not organized in the way that your typical organized armed group is going to be organized. This is a bit more about organization here than intensity. They're not really created to fight a state or some other group. They really, the way they function is to act clandestinely, to engage in terrorist attacks and so on. So this is just something that I wanted to flag. I don't think that we should necessarily make this link. Absolutely, there are definitely highly well-organized groups that are also terrorist groups, where we're talking about the Islamic State, for example, in its heyday, which has been both listed by the UN Security Council and is considered internationally a terrorist group, but is definitely, I think it's very difficult to say that ISIS was not in its heyday an organized armed group. So just a few reactions. So to summarize my views is they're not necessarily linked. There are some things that we should bear in mind organization-wise, maybe even intensity-wise, when conducting the classification exercise if we know that we're dealing with a bona fide terrorist group, but this is not determinative in any way of the classification exercise.
Thanks, Pavli. Now we have a question that has been specifically addressed to Thomas. It's about a recent ICC jurisprudence in the Al-Warfali case in Libya. And so in that case, the ICC, but also the Commissioner of Inquiry on Mali, apparently took aggregated violence in the country as a whole, instead of assessing intensity in bilateral separate relations between belligerents. What would be the problem as long as the armed groups involved are organized?
Thank you. And I must acknowledge I have not read such case law, so I will look at them. But I cannot comment it with precision. As I said, in how ICRC approach of classifications in coalition warfare, we don't allow for aggregating violence as a whole. As I said in my presentation, our approach will not lead to a situation where we'll say the level of violence is high, there are numerous armed groups, so there is one armed conflict altogether. The approach we suggest is for cases where we can link the acts of violence to a single potential armed conflict between two identified sides, but on one of these sides, there are several organized armed groups working together. So we need these additional elements to use our approach. And maybe if I can rebound on that, maybe asking questions to the other panelists, maybe especially Pavle and Anissa, because I asked myself this question hearing you. Actually, if we take a step back, really generally speaking, do you accept at all the scenario or the possibility that we might have an armed conflict involving more than one party on one side at all? Or is it completely impossible because it's really the bilateral relationship that trumps everything, and it's one party against another, and that's it? So that's the genuine question I have, and a follow-up question of to that, maybe how would you deal with it's more states coalition, but still it's the same reasoning with coalition warfare by states. We've seen that in Afghanistan, in Iraq, in Syria, etc. Do you need to classify potentially 15, 20, 25 different armed conflicts, or do you consider there is one armed conflict involving a coalition of different parties? Sorry to
no, please. Anissa, and then maybe Pavle reacting to Thomas's question.
No, thank you, Thomas, for this question. It's a tricky one. I think I would tend not to consider a party to an armed conflict as being one single party. So let me rephrase this. Like when we look at state coalition, so we agree that there is a coalition of states, but for each state we do consider whether each state is not a party to the armed conflict or not. And we using we can agree or not with the theory, but we can use, for example, the support-based approach to determine whether a state is actually a party to this to the armed conflict just by being, supporting the work of the coalition or the military action of the coalition. And I think it should be the same for armed groups, actually, because for armed groups, if we take the high threshold of central command and structure of the armed group, for example, I can give you the SDF, the Syrian Democratic Forces. It's a coalition of armed groups of different factions, but there is a central command, and the IHL orders or the training or the orders are given through the central command. So for me, this, although it's different battalions which are we could say there are different separate armed groups being part of this SDF, one as being considered as one armed group, then yes, I would agree with this. But apart from this scenario, to me, it's quite difficult to consider a myriad of armed groups as being one single party to an armed conflict, because again, I think here, although I understand how it is necessary from an operational point of view, I still think it would create more problem than the others, especially, you know, if one single armed group is not able to implement certain obligation or not, and this for me is still problematic, but I do understand the problem when you have a myriad of armed group, you know, acting together or with somehow a common goal in a specific conflict. But still, I would not agree to consider them as one single party to an armed conflict. So I'm not sure it helps in the discussion. It is complicated, but that would be my first general feeling.
Thanks, Anissa. Pavle?
Just very briefly, thank you, Thomas. That's a fantastic question. It's on the spot. So very briefly, so you asked about whether we would accept the existence of multiple parties to any armed conflict. My answer would be yes to an international, definitely, to an international armed conflict. I mean, this is something which is well known historically. We had a bunch of states during the Second World War, for example, in South America, declaring war on Germany with no actual fighting. They were all co-belligerents with the Allies. When it comes to non-international armed conflicts, now that, again, I find more problematic because first of all, I know that especially when this is not something that we have been discussing very much today, and I really don't think that, I mean, we could have an entire another panel with the ICRC support-based approach. Even there, I would say, well, you know, the support-based approach is developed for states parties to an IAC. It's not developed, at least not initially, although there are doctrinal tendencies now to try and somehow transpose the support-based approach to armed groups. Now, to be honest with you, like, I can't tell you an exact positive law reason why we shouldn't be able to do this for armed groups, but any sort of mechanism that you would suggest, or at least what I've seen so far and what I've heard, in relation to how we could use something that we use for states, we use it to armed groups, I see some issues with it. And this is the case with, for example, in one way with aggregating or accumulating intensity, which is not necessarily about coalitions, if you will. It's about using co-belligerency for armed groups, like as discussed, for example, in the article by the chapter by Vaius Koutrolis that you mentioned, as discussed by some other lawyers, by using the support-based approach. And ultimately, I also don't necessarily see why we would even need to engage in such legal gymnastics to try and develop to try and adapt, let's say, some IAC criteria on state coalitions to non-state armed groups, because I do feel that in the majority of cases, we can either use the existing, well, actually, to the best of my knowledge, which is of course imperfect, I do feel that the existing criteria are by and large adequate. So I would stick to the sort of bilateral fragmented approach for the time being. So in a nutshell, I would accept this in IACs. In NIACs, maybe, but I'm not entirely convinced for the state part, for the state's belligerents, but not for the non-state actors.
Emily, if I may just add something, which I think is important, and you know, I think it's also important to look at what armed groups say themselves about this coalition. How do they perceive being or not in a coalition? And I would, as you know, as Jan said at some point, these coalitions of armed groups, they cannot somehow. It's very difficult to believe that they will have a common policy or a common operational action for you know, a long time, stable, which would be stabilized, because they can move very easily, because one armed group can decide, for example, to sign a peace treaty while not the other. And so to me, it's also important to understand how they project themselves, whether or not they project themselves to be in a coalition or not. And I know that it's not necessarily a condition for considering whether IHL is applicable or not, but still, to me, it is also let's say, something that we should endeavor to do, only because they might be also brought into a situation where they would need to think whether IHL is applicable to what they are doing when they're fighting either, for example, other coalitions of armed groups. So we only think from the point of view of either states trying to determine whether IHL is applicable or not, or international organizations, or us, like, as scholars who are very comfortably seated in our chairs and have the leisure to think about all these complexities and niceties. But I think it's also important to consider what these armed groups are themselves thinking about these issues, and whether or not they consider to be in a coalition with coordinated targeting policies, or implementation of their military action. So I think this is a very important thing to consider when we are holding all this discussion about conflict classification.
Thanks, Anita. I see Thomas raising his hand, and then Gloria, and then I think we're going to have to conclude.
No, thank you. It's fascinating conversations. I just want to continue it. I think there is no cogent reason to treat different parties differently, whether states or non-states, for classification purposes. And by the way, regarding the support-based approach, we have a publication where we say there is no reason why we should not apply it to non-state armed groups. So I'm sorry to disappoint you, Pavle, because it does not go in your direction. But I think there is no reason why we would have a different approach for non-state armed groups. So theoretically, it could apply according to us. Importantly, the support-based approach, I think it's important to remind that it's not a tool for classification purposes for new conflicts. It's only for adding parties potentially who might join a pre-existing conflict. So it's slightly different, because if we talk about classification of new conflicts, it's not a tool that we use from the start. And I think it's also important to clarify that there is a difference between coalition of several parties and a coalition forming a new single organized armed group. I think it's two different things. And indeed, because Anissa, you referred to control or to command factor in terms of the factual factor that we have to look at. Actually, I completely agree that when there is a sufficient level of command, and I would use actually the notion of command and control in order to assess whether a form of coalition actually is strong enough to create a new entity, which would be a new single armed group. But for that, I think we need to have a kind of high threshold of command and control, which entails, in my view, kind of a relationship of subordination of the entities that will join this new single armed group. So really concrete elements regarding the hierarchical structure, the chain of command, the centrality of command, etc. Things that don't necessarily exist in a little bit more loose coalitions, where the different parties forming that coalition keep their independence, their own chain of command and control structure, and therefore it's kind of in the middle between a pure fragmentation approach and a creation of a new single entity formed by the coalition. And this is this small gap that we try to cover here.
Thanks, Thomas. Gloria?
Yes, thank you very much. I'm abusing my role because I'm not on the panel, but I wanted to just share some thoughts with you based on what you said, Thomas, about your question, which I think is a very important question to ask. So why would we have an approach that would differ for states and for non-state actors? And why would we have an approach which would differ in international armed conflicts versus non-international armed conflicts? First point is that for international armed conflicts, we are in a completely different debate. I mean, in international armed conflict, there is no high threshold of intensity that needs to be reached. So here there is nothing to construe really. So I would set completely aside this situation. Now, when it comes to non-international armed conflicts, I still believe that there is a crucial difference between the approach that we would take for states, coalescing, for instance, and for non-state actors. And this is the fact that it is extremely difficult in current situations of armed conflicts to determine what are the boundaries of the group and whether the group is sufficiently organized. So Thomas, when you presented also your approach, you said, well, the assumption is that we are faced with groups that are sufficiently organized. So it's as if you put outside of the debate the organization through a theoretical approach, which makes total sense from theoretically to say, well, we suppose that they are organized. But now when we compare that to the reality, we are confronted to situations where it's very difficult to know whether they are actually sufficiently organized or whether to know whether those projecting violence actually belong to such a group or actually belong to such a coalition. So actually, it's not like states where it's clearly defined, you know what the state is. It's not the same for organized armed groups, especially in current situations of armed conflict. And so somehow we have two criteria that are normally at the basis of the classification and which are both shaky. The organization is shaky and the intensity is being construed. So then when we look at those two things and we still have them together rather than dissecting the two, we see how it is normal to have an approach that is distinct for states where organization is clear and for non-state actors. So I'll stop there. Thank you.
Thanks, Gloria. I'll give a right of response to Thomas, and then I think we'll need to wrap up.
Yeah, no, thank you very much for that. I'm sorry if I was not clear enough in my presentation about organization. Actually, I don't put aside organization at all, and I don't assume organization. I think I said it's really important to first assess the organization of the parties we want to classify as members of the coalition, as parties to the conflict. So it's a prerequisite to use our approach that the parties we are talking about are organized in the sense of IHL. So we really don't get rid at all of the organization criteria. Sorry if it was not clear.
Thank you. I think we're going to stop here. My apologies to everybody who asked questions in the chat that we have not been able to address. I hope that the selection of questions nonetheless made for an interesting discussion. I'd like to thank our distinguished panelists for sharing their views and also exchanging ideas in such a lively way, despite us being online. And without further ado, yeah, there was a 15-minute break happening, and then the conference will resume with the second panel at 4:05. And I wish everybody a lovely afternoon.
Hello, everyone. Welcome back to the conference and for this second panel. First of all, I would like to thank you again, the first panelist, for the very engaging discussion, and also all those who participated with questions. We are going to follow the same format for this panel. So please do write your questions in the chat, and then we are going to answer in the Q&A session. Now, with regard to the second panel, the topic is going to be cyber conflicts. We are going to focus also on classification, but not only. The thing is that with new military technologies, we have new challenges for IHL, and not only, and the first challenge is actually whether IHL is applicable in the first place or not. What is the legal framework? And once we have identified the legal framework, that we believe fits well cyber operations, then the question is how the legal framework chosen is going to be applicable to cyber operations. So the cyber sphere has created many new challenges, and I'm very excited to be here with 4 distinguished panelists that are going to address these issues. So thank you very much for being here. We will start first of all with Professor Marco Roschini, who is professor at the University of Westminster, and then we are going to have François Deleroux, who is senior researcher in cybersecurity governance at Leiden University and team lead on international at the EU Cyber Direct. And then we have Henning Laman, who is Dr. Henning Laman, who is postdoctoral global fellow at New York University, as we can see from your picture on the background. And then we have eventually Professor Vera Rusinova, who is professor at the National Research University of Moscow. So thank you very much for being here. I look forward to hearing your presentations and the ensuing discussion. And Professor Marco Roschini, you have the floor.
Thank you, Chiara. And thank you, Gloria and the Academy for inviting me. It's nice to see so many friends and colleagues again, if only online for now. So I've been asked to talk about, right, sorry, I was just trying to arrange everything on my laptop. So I've been asked to talk about how the definition of international armed conflicts applies in cyberspace. So I've got the easy one. I've got non-international armed conflicts, which will be addressed by the other speakers. Even though it raises different and perhaps less issues than the definition of non-international armed conflicts, still, as we'll see, cyber technologies raise interesting problems also in relation to the applicability of the law of international armed conflicts. It's been said already several times today, the classification of armed conflicts is the first step of any international humanitarian law exercise, as the applicable law depends on the type of conflict involved. And the same applies to armed conflict classification in cyberspace. Classifying the conflict is necessary to establish whether and what IHL rules apply to cyber operations. As you probably know, several states now have published their positions, official positions on the applicability and application of IHL and international law in general in cyberspace. But it is interesting that while the vast majority of states, with some notable exceptions, agree now that IHL applies in cyberspace, the documents I was referring to, the documents highlighting their position on the application of international law, including international humanitarian law, do not address the classification problem or the application of the definitions of international and non-international armed conflicts in cyberspace. More specifically, from what I've seen, it's only France, Japan, Brazil, Germany, and most recently Italy that briefly address the question of the definition and classification of armed conflicts in cyberspace. Germany and Italy, by referring to the ICTY study judgment. All the others are silent on the issue, and either they don't say much about IHL at all, or briefly look at the main, the basic IHL principles as distinction, the definition of attack, etc. in cyberspace, but they do not address, as I said, the classification issue. So there's not much opinion juris or state practice at the moment. if one applies the Tadic definition in this context, in the cyber context, and particularly, as I said, looking at the definition of international armed conflicts, we see that we have basically two elements that make an international armed conflict, including in cyberspace: resort to armed force and between states. Now, I'll look at both these elements if quickly and make some considerations in relation to how they apply in the cyber context. So resort to armed force, what is it in cyberspace? I should say from the beginning that resort to armed force is not the same as the use of force as used in Article 2, Paragraph 4 of the UN Charter, which is a broader notion. We know that according to the ICJ, at least, it involves not only the actual use of weapons, but also arming and training, for instance, armed groups. And Article 2, Paragraph 4 also addresses threats. Again, this is not resort to armed force for the purposes of the determination of the existence of an international armed conflict. Having said that, once if the use of force does involve the actual use of weapons, it doesn't need to reach any scale on or effects levels in order to trigger an armed conflict. Resort to armed force in IHL rather refers to the resort by the parties to the conflict to means and methods of injuring the enemy. Obviously, that doesn't mean much if we don't know what injuring means, and particularly what injuring means in the cyber context. Some positions and some documents and scholars, including, if I remember correctly, the Tallinn manual refer to the notion of hostilities. So the resort to armed force, an international armed conflict, and therefore the resort to armed forces would be, the exchange of hostilities between states in case of an international armed conflict. But I think that the notion of hostilities is still too broad. I think we need to distinguish between the hostilities that can trigger an armed conflict and hostilities which occur during an armed conflict, but cannot initiate one. And this would be the case of non-violent hostilities, for instance, logistics or psychological operations, intelligence gathering. This can undoubtedly constitute acts of hostilities, which are governed by IHL if they occur in an ongoing armed conflict, but cannot start the conflict themselves. In order to start a conflict, the hostilities need to be violent, which means they need to result or be designed to result in violent consequences. That's certainly the case. I think there's broad agreement on this. That's certainly the case when the cyber operations are designed to cause physical damage, either to persons, property, or both. If the cyber operations the results, the consequences of the cyber operations are similar to those of kinetic attacks, then an international armed conflict is triggered. If the other element, the between state element, of course, is also met. And this is what, for instance, the 2016 commentary to Common Article 2 says. It expressly refers, unlike, of course, the old commentary, to cyber operations and cyber operations with violent consequences in particular. What is more controversial is the situation, the qualification of cyber operations which do not result in physical damage to property or persons, but in the loss of functionality of physical infrastructures. And referring again to the 2016 commentary of Article 2 paragraph or Article 2 common to the Geneva Conventions, the commentary says that the law is uncertain on this point, and it's difficult to disagree with them. As far as I am aware, no state has so far adopted an official position on this issue, whether the mere exchange of cyber operations by one state against another, cyber operations that only cause a loss of functionality or malfunctions to physical infrastructure, is able per se to to trigger an international armed conflict. Obviously, an argument in favor of this conclusion would be the fact that today's societies largely depend on computers, computer systems, and networks in order to provide essential services, which means that the states now have the ability to cause harm, damage to other states, significant damage to other states, even without the use of destructive means. It is interesting, for instance, that in the context of the UN discussions, early in the day, Panama said that the misuse of ICTs is a new form of violence. And I quote from what I remember that document said. It is entirely possible, therefore, that state practice and opinion juris will evolve in that direction. That what matters is really that the state becomes unable to provide certain essential services, however that happens. But fair enough, as the 2016 commentary says, it's probably too early in the day to draw any definitive conclusion on this issue. The other problem, the other element that needs to be thought through in relation to resort one force in cyberspace is that of whether this resort one force has to reach a minimum level of intensity. It is well known that states often treat incidents of short duration or of limited consequences as events short of war. And it is a fact that it is only when the damage, the more the damage, the more protracted the event, and the more likely it is that the situation will be treated as an armed conflict. But it is also well known that the ICRC does not, the official position is that there is no minimum threshold for international armed conflicts, unlike for non-international armed conflicts, as has already been said today. Any difference between states that leads to the intervention of their armed forces is an armed conflict, whatever the duration, whatever the number of casualties. And it is a view that finds support, of course, in Common Article 2 itself, which envisages the application of the conventions, even in the case of a mere declaration of war, or even when there are no hostilities at all. For instance, in the case of an occupation which is not met with armed resistance. It also makes sense from a theological perspective, because obviously it fits the purpose of extending IHL protection as widely as possible, and also avoids the risks of abuse, which would be linked to determining the exact threshold when the armed conflict, the international armed conflict, would actually start. Obviously, if the resort to armed force is limited, IHL would apply, but it would only be a very limited number of rules. Having said that, and assuming that the ICRC is correct on this point, that there is no minimum intensity threshold for an international armed conflict to arise, it has to be said that in case of cyber operations that result in loss of functionality and not in physical damage, if, and as I said, it's a big if, we assume that they can initiate an international armed conflict, I think that in this case, an intensity threshold is unavoidable, meaning that only significant disruption of critical infrastructures would be, in my view, able to determine the existence of an international armed conflict. And this threshold is not really for a resort to armed force to be an armed conflict. It would be for a cyber attack to be a resort to armed force, because it is only in case of significant disruption that the effects of a cyber operation can be equated to those of destruction caused by traditional kinetic force. As to the second element, the between states element, the cyber operation has to be conducted by state organs, agents, or entities empowered by the law of the state to exercise elements of governmental authority. This is from the articles on state responsibility adopted by the ILC. On the other hand, the governmental or private character of the attacked infrastructure would be irrelevant for the determination of the armed conflict. And this point fits very well, accommodates very well the fact that many national critical infrastructures are in many states now privately owned. The between states element of the definition of international armed conflict makes also operations which are the result of error incapable of triggering an international armed conflict. And this again fits very well with the characteristics of cyber operations and of software and malware, particularly because of the likelihood that malware can inadvertently spread to many countries, not just in the target state. Obviously, the elephant in the room here, in the between states element of the definition, and therefore on the existence, on the determination of the existence of an international armed conflict in cyberspace, is attribution and evidentiary problems. If we cannot establish with reasonable certainty that who is responsible for the cyber operations, and therefore if we cannot establish that the resort to armed force is between states, qualifying an armed conflict as international or non-international becomes impossible. And I'm sure you are very familiar with the many techniques that make cyberspace a big masquerade ball, like IP spoofing or the use of botnets and so on and so forth. Even when there is no legal attribution, however, an armed conflict is internationalized if a state exercises overall control over an organized and hierarchically structured armed group operating against another state, which means, using the ICTY language, which means that that state, the third state, has a role in organizing, coordinating, planning the military actions of an armed group, plus it finances, trains, equips it, provides operational support to them. In cyberspace, arguably, this overall standard could be met if a state provides an armed group in another state with malware designed to cause a physical destruction, and with the necessary training to use it, as long as it also organizes, coordinates, and, as I said, plans their actions. This would be the situation of an exchange of cyber operations that it's a pure cyber conflict. It goes without saying that if the cyber operations are conducted in the context of an ongoing armed conflict, traditional armed conflict, as happened already, allegedly, in the case of Georgia in 2008, and more recently in Ukraine, in the conflict in Ukraine from 2014-15 onwards, on several occasions. So these cyber operations conducted in the context of a traditional conflict would be regulated by the law of armed conflict, providing that they have a belligerent nexus with it. So they are conducted in support by a party, in support of the military effort of a party to the conflict, to the detriment of another. This is a point made that I borrow from the German position on the application of international law in cyberspace. I don't have much time left, but just to say that This, however, doesn't necessarily make the situation easier, because it might be possible that the traditional the cyber operations will have started before the beginning of the traditional armed conflict, and then they continue during the traditional armed conflict. And that's the case, for instance, of Georgia, where the distributed denial of service attack started in mid-July 2008, while the invasion started, I think, was the first week of August 2008. So did the conflict start when the invasion of Russian troops occurred, or did it start 2-3 weeks before, when the DDoS attack against Georgia started? Obviously, the problems are the same as the problems I highlighted in relation to pure cyber armed conflicts. And finally, as you know, that we have an international armed conflict also in case of wars of national liberation, a declaration of war, which could be, by the way, which could be made these days not only through traditional means, but also by cyber means. For instance, one could think of social media and the use of Twitter, as it has been by not for declarations of war, but there is widespread use of Twitter by heads of state, as we know, use or abuse. Recognition of belligerency is another situation where the law of international armed conflict will be triggered, and situations of partial or total occupation. So I'm concluding here, just to say that there was this, I was at another conference actually last week, when Francois was also there. And one of the speakers referred to a Greek myth in another context, but it suits me very well here for my topic as well. And that's the myth of Procrustes. Procrustes was a giant and a bandit in Greek mythology, son of Poseidon, and had a bed in which he tricked travelers to sleep at night. And if the guest proved too tall, he would amputate the excess length. If the guest was too short, he would stretch them until they die. So it was quite a gruesome myth, and nobody ever fitted that bed exactly. And he continued his reign of terror until eventually Theseus captured him and killed him by fitting him on his own bed. So my point, and that's why I'm telling the story, is that as I hope I've managed to explain, the definition of international armed conflict does not need to be stretched or amputated in order to fit the Procrustean bed of cyberspace. It is flexible enough to accommodate the special features of cyber means and methods of warfare. The crux of the matter is not really the definition itself, but is the anonymity of cyber operations and the well-known problems related to evidence collection, which makes the application of international law, including of international humanitarian law, factually problematic when it comes to cyberspace. And I'll stop here.
Thank you. Thank you very much, Marco. Now I give the floor to Francois. Thank you.
Thank you very much, Chiara. Thank you very much to the organizer for inviting me to speak at this great conference, this great event. My name is François Delerue. I am a senior researcher in cybersecurity governance at Leiden University, and I am expert in international law for the EU Cyber Direct Initiative. So my presentation will be focusing on non-state actor in cyber conflict, cyber armed conflict. My idea with this presentation is not to deliver a course or on the question of non-state actor in armed conflict. There is already an important body of literature on this question, but rather to actually raise some points, raise some questions, and give my humble comments on the answers to them. So I will first start with some challenges related to the very nature of the conflict, to the classification of the conflict. We just heard Marco on this question, so I will not go too much on that questions, but I think there are some points that are very interesting in the ways that non-state actor may be involved in armed conflict. through cyber means that are also particularly important for the qualification of the conflict. So the way non-state actors are taking part in hostilities are of limited interest for the definition or characterization of an international armed conflict. So I will not go on that. I will just come back later on this question about the geographical scope of the armed conflict, but that's another question, so we'll talk later about it. Conversely, the modalities of participation of non-state actors in hostilities through cyber means create specific challenges regarding the definition and characterization of non-international armed conflicts. A non-international armed conflict is a conflict involving at least one armed group fighting either against a state or against other armed groups. Thus, there will be the involvement of an armed group, and for a cyber non-international armed conflict or international cyber, the non-international cyber armed conflict, you will need to have mainly like the hostilities taking place in cyberspace or through cyber means, and to reach a certain level of intensity. And here's the first point I wanted to make by saying that, which is more a practical one than a legal one, but is that it's, for me, unlikely to happen in the sense that it's likely that in a situation where the criteria of a non-international armed conflict were to be met, the hostility will not be confined to cyberspace. In other words, it will be an armed conflict potentially taking place to a large extent in cyberspace, but there will be also hostilities in the real world, either, for example, targeting the combatants on both sides in the real world, but also targeting the physical infrastructure that are used for the transit, the creation, the launch, and so forth of the cyber attacks. So that's for me an important first point to make is, from a non-international armed conflict perspective, I believe it will be very difficult to have such type of conflict. And then if we take the categories and the condition of the second additional protocol, where you add some layers, such as the territorial control, all these things, it's becoming really unlikely, if not impossible, to have such a control exercised only through cyber means. So it's where, for me, having a non-international, purely cyber armed conflict will be difficult. Moreover, I think there are two important features of the cyber realm that are particularly important when discussing the conduct of hostilities in cyberspace. The first one, and which relates a bit to what was just said, is the possibility to incentivize people to act in a certain direction without exercising control over them. And I think that's one of the very important points about cyberspace, because cyberspace has rendered this possibility even easier, with the possibility for an actor, either a state or another actor, to incentivize individuals, either located closely, also from a far distance from the battlefield, to take up arms against one or the other belligerents. And cyberspace then also provide to these cyber partisans, we may call them. We can also talk about patriotic hackers, that's a word that has been used in the past. Both an easy access to effective tools to act, but also the capacity to conduct these operations, this cyber operation, from a remote location from the battlefield. Second feature, closely related to the previous one, is the possibility for a group of hackers to act together toward a certain goal with a very limited level of coordination and organization. The best example on that, which is not really like, has been involved in armed conflict, but which is not really an armed group and not recognized as a belligerent to a conflict, is the group Anonymous, which is a good example. And it's not really a group in the sense of coordination of organization, but rather an heterogeneous gathering of people working toward common goals, in the sense that they will not be part of every action of the Anonymous, but each individual may or may not join each action specifically depending on its interest and its goal. So that's also one, I think, like these two features create, I think, important challenges, because you have this capacity of groups of various dimension, various nature, various level of cooperation, but also this capacity to link people and to incentivize people that will be located in a very different location to act toward a certain direction. And I think one of the best examples on that remained, like the case study, remained the 2007 Estonian case, I will not discuss whether it was an armed conflict. We just heard about international armed conflict before, but I think it's an interesting one to exemplify this capacity of involvement of non-state actors. Why? Because in 2007, what we saw is that Estonia suffered a large-scale wave of distributed denial of service attack against computer infrastructure of the government, media, banks, and other targets. So these DDoS attacks is a type of attack where a server is saturated with requests of connections that make it no longer accessible. So there is no destruction, there is no loss of data, but there is a problem in the functioning at a certain time of the server, which is no longer accessible. What is interesting in this case is such attacks are generally conducted by numerous actors at the same time. And in this case, Russia has been mentioned as a possible responsible actor, notably by Estonian officials. The Ministry of Defense back then made a comment in that direction. But what is likely to have happened, and what we see in most of these cases of distributed denial of service attack, is that yes, there may be a main actor. There may be, for example, in this case, it could have been Russia. It has never been really proved. That was carrying out some cyber operations through its organ or its agent. But also a big part of the cyber operation were actually conducted by individuals, incentivized by online messages on different social media or online platforms to act against Estonians, that they decided by themselves to download the DDoS software and to take part in the attack. Thus, in such case, what we can see is how individuals can effectively be incentivized to act and actually contribute to a large extent to the hostilities. Moving forward from that, so what I wanted to show here is this capacity for an armed conflict to actually spread over like individuals and how these individuals will be involved in this armed conflict, which trigger one of the very important questions regarding armed conflicts, which is the involvement of non-state actors in the question of civilian direct participation in hostilities. One of the main issues on this question remains this question of revolving door. So having this capacity for civilians to be civilian by day and combatant by night, which remain an important question and that trigger a lot of work in the past, notably the ICRC guidance and direct participation in hostilities. But what we see with cyberspace is that it's even quicker to shift from one function to another, to be civilian and to be combatant in a very short period of time. So the first difficulty then is to identify what constitutes an actual participation and also to distinguish that from preparatory measures. And that remains an important issue in cyberspace. In theory, it's possible to distinguish between the two types of action, but in practice, the question is much more difficult to address. Breaking into a computer system is generally only one part of a more complex action, and it might sometimes be difficult to distinguish clearly when the action started and when it was only a preparatory measure. When the coding and the testing of a cyber operation move from just a preparatory measure to the actual conduct of the act. When the creation of an exploit aiming at penetrating into a specific computer system move also from a preparatory measure to an actual cyber operation. The other challenge is the duration of the direct participation in hostility, and that's a general comment for cyber warfare, for cyber operations. Because one of the issues is, on the one hand, you can have cyber operations that will last for a few seconds, and that creates a first challenge. But you have also, on the other hand, cyber operations that are conducted over months, if not over years. And in such case, it might be difficult to identify within this time frame which part of the operation is an actual conduct of hostility, which part will qualify, for instance, as a direct participation in hostilities for the civilian, and which part will be only preparatory measures. So that creates another challenge for this notion. So for me, what is important here to see and what may affect this question will be the development of such practice. And if this question was to be repeatedly asked, we may wonder whether we'll not see groups, specific groups, developing a certain modus operandi that will facilitate the blurring the line between participation and the civilian status, and then helping them benefiting from a certain level of presumption of civilianity. These commands and challenges are not cyber specific, and we see this blurring line between civilians and combatants is a reality for modern warfare. But what I think and what we see with cyber warfare is that it's becoming even more important in cyberspace since it brings them to another level. Moving forward from this question of direct participation, I would like to talk also about another aspect, moving forward on this question, another aspect of the interpretative guidance of the ICRC, which concern how to target the civilians that has been identified as taking direct part in hostilities. And one of the debates there, which was one of the most controversial part, was actually the fact that you should use a less harmful mean to target a civilian taking part in hostilities. Translating this question into cyberspace, what we see is you have a person that will be using a cyber tool, that will be using a computer and computer network to target other computer networks, meaning that you can disable his capacity to act just by disabling the computer. So in such case, we may wonder whether this question of using the less harm would actually also affect this question and call for targeting them through cyberspace rather than targeting them from the real world perspective. I will now finish my presentation with, for me, what is the most important question for both non-international and international armed conflict in relation to the development of cyber means, which is the geographical scope of the conflict. So in a recent year, a limited number of states have developed the practice of publicly attributing cyber operation to other states or to sanctioning their authors. I will not elaborate on that, it has already been mentioned, yet one of the interesting elements that we may observe in this practice and in some of these cases is that the action allegedly conducted by a state have actually been carried out by a group more or less linked to the intelligence services, which is located on the territory of a third state. There have been accusations, for instance, from the United States against North Korean groups acting from the territory of China or Russian groups acting from the territory of Ukraine, targeting either the country in which they are located, that was, for instance, the case with Ukraine, but also targeting other countries. In such a situation, in the context of an international armed conflict, it may create a challenge for the territorial scope of the conflict, but also in some cases, on the question of neutrality of the other states. It is generally considered that the mere transit of the cyber operations through the network of the neutral state will not affect its neutrality, but it's different when you have a group acting on behalf of another state from their territory. We have already mentioned that before, but also on the question of direct participation on hostilities, I think what is important to see here and what creates another challenge is we have those people that will take arms through cyberspace within the geographical scope of the conflict, but also those who are located outside of the conflict, which ask questions in terms of internationalization of the conflict, but also question the limits of international humanitarian law in the sense that most of them will be located outside of the scope of the conflict, and then you need to use and to rely on other legal regime, notably on cooperation between states, to identify and to arrest or to put an end to these actions. So I think that's a very important challenge we see with these questions. And the last point I wanted to make on that is also how to approach legally the situation where actually a state party to an armed conflict will identify civilians taking part in the conflict, not from an IHL perspective, but from the territory of third states, and will decide to act through cyberspace against these individuals. This will also create various legal consequences in terms of violation of sovereignty, but also in terms of what the state is doing against this person, which I think will raise several questions. To conclude my presentation on non-state actor in cyber armed conflict, I would like to restate two main challenges I identified in my presentation. The first one concerns the type of actions that may be conducted by non-state actor in cyberspace, in the sense that cyberspace has been offering new means and transforming the way this action may be conducted, but also transforming the question of coordination. And the second one, which for me is the most important one, is the challenges to the territorial scope of IHL. Thank you very much for your attention.
Thank you very much for your very interesting presentation, and I look forward to the discussion during the Q&A. But now I don't want to lose too much time, so Henning, please, you have the floor. Thank you.
Thank you, Chiara. Good morning from across the Atlantic. For me, still good morning. Good afternoon to all of you in Europe. And thanks for Chiara and the Geneva Academy for having me. I always enjoy working together with you on these issues. I'm going to touch upon a few aspects that I guess mostly Marco has already addressed in his very clear and concise presentation about what we mean when we talk about armed conflict in a cyberspace. So I just want to add on to that really and maybe take a step back and talk more about what I think is the blurring of the lines that we see between what we've traditionally considered peacetime, however we want to define that, and situations of armed conflict that I think have become more and more ambiguous, and I think this has like important legal consequences and implications when we talk about the application of international humanitarian law to cyber operations. So what we've seen in the past couple of years, and especially since the beginning of the pandemic, is as more and more we see more and more cyber operations apparently or obviously conducted by states, either through non-state actors or through their own armed forces or intelligence services that have very grave consequences for civilians, civilian objects, and the civilian society at large. When targeted, we've seen ransomware attacks against hospitals, so ransomware that freezes all data in a hospital, and then that hospital can't function as normally anymore. We even had maybe a death because of that, a patient not being able to get treated at a hospital. We've seen cyber operations against power grids in several countries. But we've also seen a lot of just data breaches that affect maybe civilian societies in different ways that have not like less tangible consequences, but are still maybe very intrusive in terms of the privacy of the targets, and can maybe be exploited by the state who's conducting these operations to then blackmail persons or even whole societies. We've seen, of course, meddling with democratic decision-making processes in different countries over the past years that also have been conducted by cyber means. So we've seen this kind of sometimes being called a hybrid warfare that has very pronounced and I think important and grave consequences for civilian societies. But the question is, what role does or can international humanitarian law or any legal regime really play in that space? Because what I see is that states have really started to realize how vulnerable adversarial societies have become through the digital transformation. They have a much larger target surface. There's much less today maybe a need if you want to, as a state, coerce an adversary to use physical means, to even like use a threat of force, because you have all these tools at your disposal that you can use against other states, other societies. And the question then becomes, if we see that the targets are very often, or at least the victims of these operations are very often civilians and civilian objects and societies, what can we do about that? Because of course, in what we have in IHL is a web of very detailed rules of targeting. We have the principle of distinction that if you have a military operation within the context of an armed conflict, you're not allowed to target civilians. If civilians are in the vicinity of an attack, you have the principle of proportionality. We have all these rules that are very detailed, and we have a lot of state practice and jurisprudence on them. But of course, what we see, and Marco, of course, touched on that, is that in a lot of these cases that I've just described, IHL does not play a role because we cannot speak of the existence of an armed conflict. And I think this is more and more becoming a problem. Of course, the ICRC at this point would stop me, and they always stop me here, and they say like, well, but if we have an armed conflict between two states, of course, the rules of international humanitarian law also apply to any type of cyber operations that these parties to the conflict would conduct against each other. So we just had an armed conflict between Armenia and Azerbaijan, where we saw certain types of cyber operations that they conduct against each other. And of course, in these situations, we have the rules. Of course, we have a lot of, we're not really sure how to apply them. For example, like what is an attack in cyberspace and all these questions, but at least we are sure that we know we can apply international humanitarian law. And as Marco also described, of course, there are situations in theory, at least, where like a cyber operation can trigger the application of international humanitarian law if we have certain physical consequences, if we reach a certain threshold, and then I think the right view is that we apply international humanitarian law to like these cyber operations themselves. But the problem is that in most situations, this is not what we see, and this is probably not what we're going to see in the coming future. I think when we all started talking about international law and cyber operations in the early 2010s, there was always this idea of we're going to have like a cyber Pearl Harbor. We're going to have all these like devastating cyber attacks with big physical consequences that like, I don't know, we're all thinking about explosions, which is of course something that is not inconceivable, and this has happened and this might happen again, but this is not really what states seem to be doing in cyberspace these days. So so we have, I think, we need to reconsider how we think about the concept of conflict, and then also reconsider what the role of the law is in this space, because another feature I think that we see today is that it's not only low intensity, so below a threshold of armed force, but it's also near constant. So states are almost all the time, not all states of course, but a lot of bigger actors are almost constantly trying to breach each other's IT systems, try to get some leverage over their adversary in cyberspace. And this is really a constant process where it's also sometimes unclear how we apply the rules that we have. And I think this leads to what I said at the beginning, a continuous blurring of the line between conflict and peace. And I think that can have really serious consequences if we don't address that. But the question is, of course, what do we do about that? We have, of course, not only international humanitarian law, we have other legal regimes in international law that are applicable to these kinds of operations. Francois mentioned, I think, the sovereignty of target states that might be implicated if we have a cyber operation that has some kind of consequence that is adverse to the targeted society, but that it does not reach the armed attack threshold. We have the principle of non-intervention. But when we look at the protection of civilians, these are all rules that are, of course, very state focused. They are centered on the position of the state in relation to other states in the international arena. They're not directly meant to protect a civilian or a civilian object or civilian society. So their protection is only mediated through these rules. And even when we look at these rules, of course, we all know that they are still very contentious, they're very contested. We haven't really found a consistent, at least opinion juris, of how these rules apply to cyber operations, even though I want to emphasize that I mostly agree with Francois on these issues normally, that these rules exist and they do apply. And if they are applied consistently, of course, they provide some protection, but it's mediated. On the other hand, we have in this space human rights guarantees. So if I target a hospital and a patient dies because of the cyber attack, because the hospital stops functioning, of course, this implicates the human right to life. But even there, in this space, we still have a lot of disagreement among states and even among international courts and tribunals of how international human rights law can apply to these kinds of situations, because it's, of course, always extraterritorial. So how do we apply human rights in extraterritorial situations? I think there's a crystallizing scholarly consensus that at least when a state attacks or targets with a cyber operation another society and there are consequences for the human rights of those citizens, then this state violates its own obligations under human rights law. But this is not yet, I think, state consensus. So there's still a lot of work to do, and I actually don't see many progress in that space. So how do we go ahead from here? Do we need to think about new rules? Is that what we have to consider when we see these conflicts escalating in cyberspace that are always below a certain threshold, but they are near constant, that have grave consequences? Is that something that we need to conceive as a conflict, not as an armed conflict, but as a conflict that maybe necessitates rules that are somewhat modeled after the international humanitarian rules that we have? Of course, there are many downsides to this approach, and so I'm not arguing for this approach. I'm just throwing it out here as something that has been considered, because as soon as we think about this as a conflict, this might also have a legitimizing effect for states to carry out certain operations in the same way that if you have an international or non-international armed conflict, that certain acts of violence are at least tolerated by the law, of course, if you target certain assets. So this might be one of the effects. The same effect would occur if we try to modify maybe the application threshold of IHL. Should we reconsider what we think about when we talk about an armed conflict in the first place? Should we try to include these kinds of state actions, which I think has the same potential downsides? Or should we, and that's of course what has been happening, rather try to clarify the applicable rules of peacetime international law to these kinds of conflicts that we are seeing more and more? We have processes at the UN level that have already been mentioned. I think the UN GG and the open-ended working group. But what I think has been sobering over the past years in that space is there hasn't been a lot of progress when it comes to exactly these questions, or maybe I'm just too pessimistic and I think there hasn't been enough progress. But I'm a bit disappointed when I saw the last reports that came out of both processes when it comes to exactly these questions. How do we consider conflicts these days, and do we need like maybe a larger reconsideration of how we can achieve civilian protection against cyber operations? And this is my last point. Thank you.
Thank you very much, Henning. And now I give the floor to Vera. Thank you.
Thank you, dear colleagues. Greetings from Moscow, and thank you very much, Chiara and Gloria and the whole team of the Geneva Academy for inviting me to speak today. So I was asked by the organizers to address the issues that have been discussed during the session from a critical perspective. So now I see that Henning has already taken a number of issues, and I will try not to repeat the things that he has already articulated, and to be more critical, let's say. So this mission presupposes actually that we break free from the pure positivistic analytical frame and leave the beautiful Hall of Mirrors in Versailles, which according to Jean d'Aspermont serves as a comfortable home for international lawyers, and go outside. It will change the questions we pose. It will also change the standpoint we have. So the question will be not whether and how IHL applies in cybersphere. No, the questions will be different, because the purpose will be to find what is hidden behind the broad, if I might call it broad approach to the applicability of IHL to cyber incidents. In particular, I mean the acknowledgement that a cyber intrusion alone can be qualified as an armed conflict, or that cyber acts without kinetic effects fall under the attack notion of the IHL, or that data per se, being intangible and not material, nonetheless can fall under the notion of object used in the law of targeting. And to bring a few examples, there are not only scholars, but also a number of states which have expressed very broad approaches to the applicability of IHL to cyber acts. To bring a few examples, the Netherlands, France, the UK and Norway have at least articulated officially that they support this very broad approach. So that this broad approach constitute use or abuse of the military paradigm, where these presumably good intentions to close the gap of protection can lead? Is the path to put IHL in the vanguard of these endeavors the most effective one? So I'll try to address all these questions in turn. And firstly, let us think about whether the broad approaches constitute use or already an abuse of the military paradigm to assess harmful cyber activities. We can identify many signs of this abuse, but let me disclose two of them. So firstly, the starting point for the abuse can be found in the ontology of cyber that for whatever reasons we take for granted. Let's consider the lawyer's choice of terminology for the designation of malicious cyber acts. In the first line, thanks to Professor Michael Schmidt and then the Italian manual experts, it is a use of the military perspective that dominates, and it dominates the discourse. So we use the terms cyber operations, cyber attacks, cyber warfare, cyber combatants. By the conscious or unconscious use of these terms, we are already influenced and not neutral. And it is, as behaviorists prove, very complicated to opt out. However, as a result, the law enforcement perspective remains on the sidelines, albeit taking into account both the rise of the non-state cyber actors and all known difficulties with the attribution of the malicious cyber activities to states, problems with evidence, and both Marco and Francois has already elaborated on that. This distortion is really unjustified. Second, the signs of abuse of the military paradigm can be found in a resort to a broad approach to the qualification of malicious cyber acts. You see, I'll try to use this neutral terminology, along as cyber conflicts. Let's take as an example the new 2020 ICRC commentary to the Third Geneva Convention, where it is stated that, I quote, "It is generally accepted that cyber operations having similar effects to classic kinetic operations would amount to an international armed conflict." So the commentary then confines the issues left for the states to three questions concerning the qualification of the cyber activity that just disrupts operations or information operations, and then adjustment of the threshold and intensity requirements with respect to cyber operations that are qualified as armed conflicts. I think that this standard deserves critique. So, albeit pointing in the footnote at the DGE report of 2013, the commentary disregards that at least 3 states expressed their objections. I would say that these are not, they do not object to the applicability of IHL in cyberspace, and the last DGE report proves it, but they actually object to the legal stance that cyber act activity alone can be qualified as an armed conflict. And these states are Russia, China, and Cuba, as you know. Moreover, the contours of the corridor left by the ICRC for the states to decide can be conceived as misleading. They take aside a number of pertinent issues. Among them are at least two: the causality and the nature of the malicious act. These criteria cannot be skipped when one uses the consequential logic, and this logic stays behind the qualification of cyber activity as an armed conflict. Economic tools and information campaigns can be no less harmful in a comparison with conventional military operations. So we do not use threshold requirement for the international armed conflicts, but what are then the requirements that remain? Cyber activities can also be of economic and information nature. So isn't it an abuse to take the template from the resort to armed force and transpose it to the cyber context, losing the criterion concerning, for instance, the nature of the act? To give you an example, Japan, for instance, in its contribution to the GGE compendium this year, pointed that cyber operation alone can be an armed conflict, depending on the manner of the attack and the intent of each party. Roy Schondorf, disclosing Israeli position in 2020, also focused on the criteria of the reasonably expected consequences of the cyber acts for the purposes of this legal qualification. So moving to the second question, and even if we put all the difficulties of qualification of cyber activities as armed conflicts aside and presume that there are no entry problems, would the results of the application of the law of targeting be really satisfactory? And here there are a number of problems. First of all, what should be highlighted, and actually Henrik mentioned that IHL norms are well elaborated, detailed, and this is an advantage of this legal regime. Nonetheless, taking into account that the majority of the malicious cyber acts would not fall under the notion of attack, if we do not overstretch this notion, then they will remain covered by military operations, if at all. But there are really only very little provisions of IHL that are applicable to military operations, and it will be very problematic then to sustain the argument. The second problem arises when states try to circumvent the limitations of the scope of an attack under IHL by stretching this notion to embrace more types of cyber operations. For instance, in his remarks of 2016, US legal advisor Brian Agan opined that although not all cyber operations rise to the level of an attack, it is still possible to determine such cyber operations as an attack, considering, among other things, whether a cyber activity results in kinetic or, I stress, non-kinetic effects, and the nature and scope of these effects, as well as the nature of the connection, if any, between the cyber activity and the particular armed conflict in question. So the use of this method will result in an objective inapplicability of IHL provisions dedicated to attacks, simply because they are sought and designed to govern operations related to tangible material things. The third problem connected with the applicability of IHL to cyber operations actually embraces both questions of direct participation in hostilities and the requirement of a distinction for the combatants. And thanks to Francois, I can skip the first part and move to the problems with the distinction for the combatants. So how can individuals involved in cyber activities comply with the requirements provided in Article 44.3 of the first additional protocol and distinguish themselves from the civilian population while they are engaged in an attack? or in a preparatory operation, or when and where should they carry their arms, which arms, openly, without being objectively able to gain the privileges of the combatants. What will be the incentive for the individuals engaged in the military cyber activities to respect IHL rules? So I just leave this question open. The third question and issue is whether the broad approach to the applicability of IHL in the cyber context leads to better protection. Well, it's very complicated to answer this question in the affirmative. First of all, the norms of IHL will hardly become applicable. Why? The broad approach is underpinned by the stretch of the notions of armed conflict and attack, and an overstretch of the notion of object in the case of data. They go so far that the application of the basic rules for the treaty interpretation will not suffice. At the same time, the crystallization of the subsequent practice supporting a new way to interpret black letter or a custom, taking into account the scarcity of the positions expressed by the state so far and a lack of a compromise, would be very time-consuming. Let's also look at the question of the ability of the broad approaches to enhance victims' protection from the practical perspective, and I think that a number of panelists have already addressed this issue. So is it realistic to wait that the cyber acts will be qualified as international armed conflict, taking into account the complexity of the attribution, evidentiary issues, timing, and bearing in mind that at the current moment we are aware only of the cases of the political, not legal, attribution of cyber operations to particular states, including mine. Turning to the non-international armed conflicts, I think that Francois has mentioned this point, but I can also cite the position paper of Germany of 2021, where it is stated that cyber operations between a non-state actor and state alone may provoke a non-international armed conflict. However, this will only seldom be the case due to the level of intensity, impact, and extent of hostilities required. So the threshold might be indeed too high to be reached. In addition, assessing the effectiveness of the protection, it should not be overlooked that the application of the broad approaches to IHL can spin the spiral of violence. So Henning has disclosed one part of the story. The other part is the following one. We can repeat as the mantra the division between jus ad bellum and jus in bello for ages. But what remains pertinent is that the extension of a stretching of IHL notions of armed conflicts, attacks, objects leads indirectly, of course, to the extension of the notions of jus ad bellum notions, use of force, and also armed attack. Let me stress that it happens indirectly by shifting our understanding of what is military and what is not. As a result, the right of self-defense may well be triggered, making a possible response legal. Now I'm coming to my last question and concluding remarks. And so what are the alternatives? So once again, thank you, Henning. I can reduce this part just for a number of ideas. I think that in general, the more we move from the pure militaristic point of view, the more alternatives became visible. And instead of overburdening the IHL, we might turn to other instruments and tools that may prove to be really workable solution. I also think that what is needed is the development of hard law in the direction of precision of the outlawed cyber activities, both in peace and war times, which will serve for the protection of essential civilian data, critical cyber infrastructure, and so on. I think that the potential of already existing international human rights norms should not be underestimated. I would not agree with Henning. There is a progress also in this respect, and the European Court of Human Rights, taking into account a number of recent decisions, has indeed extended its approach to the notion of jurisdiction and the extraterritorial application or applicability of the European Convention of Human Rights. The national criminal law can be enhanced by a number of instruments, and one of them can be a new comprehensive international convention on countering the use of ICTs for criminal purposes. So this is what I call for myself the future Budapest 2.0. But you know that the members of the ad hoc committee entrusted with this mandate to draft and work on this universal convention have been elected this year, and the committee will start working on this issue. Moreover, the second open-ended working group has really very wide mandate that includes both the standard setting and international law tracks. So finally, after all these critical remarks, I conclude by pushing us to turn around and recognize that there are rays of the sun and that there are real prospects for the international law as a regulatory tool to deal with the new challenges of cyber without overburdening the IHL. Thank you so much.
Thank you very much, Vera, and also all the other co-panelists. Now we have a few questions from the audience. The first one asks specifically, what are the sources that you would indicate that might support that cyber operation might indeed trigger an armed conflict, even when there is no physical harm caused by the cyber operation, if any? And whomever wants to.
Do you want me to say something about this, as I think the question was asked during my presentation, so perhaps I can kick off. Right. Well, it's a good question, and it basically that there's no the thing is that we don't have ad hoc sources to address or to apply to answer that question. So it's not that the ICJ would have an ad hoc treaty on cyber operations, cyber warfare, call them as you want, in order to establish whether this cyber operation is a use of force, whether this cyber operation is an armed attack, or whether this cyber operation is an armed conflict, whether this cyber operation is an attack in the sense of IHL, etc., etc. You don't have treaties on this. You have a treaty on cybercrime, as Vera just said, but we don't have a treaty, an ad hoc treaty adopted in relation to state cyber operations, peacetime or wartime. And we are not, I mean, let's face it, we are not going to have one anytime soon. We can't just go around it. There's no political will to draft and even less to adopt a treaty on that. So we don't have that. We cannot expect that. What we have is the rules we have. The rules that have been adopted well before the computer age, and as per my example, per my the story, the myth of Procrustes, which in my view are flexible enough. We use what we call, and we use not just in this context, as evolutionary interpretation. Now, evolutionary interpretation does not mean stretching the rules until it becomes an interpretation contra legem. And it means being within the law, so praeter legem, but try to adjust the language if the language is intended to be forward-looking, so that it accommodates future developments. And that's actually when the law, when a rule is successful, its capacity, its capability to adjust, not just to expire like a yogurt after 30 days, but actually to be able to be applicable also in future scenarios, future when the rule was adopted, of course. And this is particularly true, I think, for IHL rules. The forward-looking of IHL is inherent in Article 36 of Additional Protocol 1. It's inherent in the Martens Clause. So this idea that no violent act in an armed conflict should be outside the law, should be in a legal black hole, because we don't have specific rules yet on that, is, as I said, inherent from its very beginning in IHL as such. So to cut a long story short, we have what are the sources that the ICJ could use in order to argue that this operation, this cyber operation, is an armed attack, etc., is the rules we have, the UN Charter, the IHL, and the exercise that the IHL judges will have to do, and that we are doing here, and that we do in these events and publications, is to try to understand how these rules and when these rules can apply. When we are stretching them too far, then we have to stop. But that doesn't mean that we cannot apply them in a forward-looking manner. That's the exercise. And it might be that these rules will be only exceptionally applicable. That doesn't mean that they cannot be applied at all. That doesn't mean that IHL should be out of the question. Sometimes the approach to IHL becomes, for Harry Potter's fun, it becomes the field that must not be named. Just because it would lead to the militarization of cyberspace. I don't believe that. I think that IHL is not permissive. I think IHL is mainly prohibitive in regulating violence. And therefore, if it is relevant, there's no need to apply it in all cases. That would be not necessarily beneficial to civilians. IHL is certainly more permissive than international human rights law. So we only have to apply when it's necessary, like a medicine. But if we have that problem, why don't we take the medicine? It's not it's going to do you good, right? Unless you take it too much, unless you take it when you're not actually ill.
Thank you, Marco. Vera, you wanted to intervene?
Yes, thank you, Marco, and thank you for the question. I think that that's indeed a problem. So how far the interpretation of the black letter provisions of IHL treaties can go, and what results are indeed justified when we apply the basic rules of interpretation derived from the Vienna Convention on the law of the treaties. The problem with the evolutionary approach mentioned by Marco might be the following one. So should we go to the ICJ? We should respect the jurisprudence of the ICJ. And the ICJ found it acceptable to resort to the evolutionary interpretation when the states have included, parties to the treaty, they have included a general term to the treaty. We have a number of such terms indeed, both in the Geneva Conventions and protocols there too. But the question might be, for instance, should we treat the pertinent issue of whether data alone can be considered as an object, for instance, that at the time or when these treaties were drafted, a number of intangible, I would like to say things, but probably not a proper term, already existed, but they were not considered as falling under the notion of object. And I mean, for instance, the radio signals or electromagnetic waves But nonetheless, what was meant was indeed only tangible or material things. So therefore, I think that even the evolutionary approach here might be limited indeed. But coming to other sources, well, we have a number of, so it's a problematic with Hardler, but we have a number of scholarly works, collective endeavors resulted in a number of different documents, and many of them are well known to you. Some are probably not as well known to you as, for instance, Oslo Manual, I think also deserves a lot of attention. But anyway, this is just, supplementary means. What else can be taken into consideration is that nowadays, I think what we face is a wave of when states themselves started to take position, to articulate the official position. Some of them are detailed, some of them are very general. But with respect of the issues that we're discussing today, as I have mentioned, a number of states have taken, so 4 states I have mentioned have taken rather broad approach. But for instance, on the other side, Israeli position can be qualified as, probably in the middle. So, for instance, they are not very much in favor of qualifying as an armed attack operations that do not lead to any effects comparable with kinetic ones. So this is a clear position they have expressed. So therefore, I think that well, we are a long way from thinking about compromise with respect of both interpretation and custom. Thanks.
Thank you very much. Marco, do you want to answer? Otherwise, Francois. Yeah, Francois, you can intervene.
Okay, thank you. No, I wanted to make a brief comment on this question and generally on the discussion we have, because one of the things also we see with cyber, which I find interesting and we need to reflect on, and I think the analogy with the medicine made by Marco was very interesting in that sense, is actually with cyber operation or cyber behaviors, we are dealing with the whole spectrum of operations that a state may be conducting, which is one of the challenges we are facing here, in the sense that we tend to approach this question from one angle or another. So for example, that's what also Vera was saying, we have this military focus. We may say it's come from one way or another, but one of the reasons also we have this military focus in different states is the fact that first we went to military lawyers to ask them how we deal with cyber operation, because it's an act between 2 states, and that's the type of way we were dealing with this kind of question. But most of cyber operation and most of the responses are actually taking place within another legal framework. It's not a self-defense question, it's a countermeasure question. And countermeasure question in the past were more the responsibility of Treasury or Ministry of Economy and so forth, but not of the militaries. And I think that's one of the things that is very interesting with cyber, and we need to take into account when we think about the rules, because we tend to come with one background and then overemphasize one side. For me, that's related to the question in the sense that that's the way we will see the self-defense question. But the vast majority will not be a self-defense question, and the vast majority of cases will be something else. Starting with the self-defense question kind of precludes the answer you may have, and that's one of the issues, I think, with that. The other element, which I think is very important and was one of the issues we saw all over the discussion we had today, is the other thing with cyber is we change why we are using the rule. We are moving from something that was exceptional to something that is a daily life experience. So there is this shift also in why we need to use a rule and how often we need to use a rule. And that's also the other challenge, I think, which is very important, which is interesting because it translates for me in a way where we want to have more legal certainty than we have in other fields. And that's very interesting, because this kind of question about the ICG, or this kind of recurrent question about adopting a new treaty and so forth, we don't have them about other type of hostile acts from state, or it's more limited. But we have it about cyber, because there is this pressing issue that every day you have cyber attacks, and you want to find, like states wants to find an answer, because the population is asking state to find an answer. And I find it also very interesting, because that's also change what we think international law is and how we approach international law.
Thank you, Francois. Now we have time for a further question that we received recently. Now, many things mentioned, I'm reading the question. Many things mentioned today as cyber attacks short of kinetic damage are not innovative. States have been blackmailing one another, launching disinformation campaigns, and so on. The cybersphere can be considered as just a new means for the same purposes. What is the difference between a spy stealing a physical document and a hacker breaking into a database? Even more, once the document is stolen physically, it obviously cannot be accessed, so this database is not fully operational anymore. Would you consider stealing a physical document an example of attack in the IHL sense? Don't you think that many issues can become clearer if we find analogies to the cyber actions in the offline world? Who wants to? Francois, Henning, you.
Okay, thank you. Yeah, it's actually also related to what I was just saying in the sense that, so first, yes, cyber is only a new mean. So that's, I think we all agree on that. Cyber is just a new mean for state to develop their activities. But that being said, you can turn your analogy in every direction you want and kind of adopt it to the answer you want to find. Yes, stealing something on the computer is like stealing a document. But the difference is when you talk about physically stealing a document, you have a cost to do it, and you may not have access to the entire picture. With cyber, it's become easier, but also you have access to much more information. And that's one of the issues, is it's one thing having someone breaking physically into an embassy, being able to, for example, take physically the hard drive of a printer and have access to the documents that have been printed for over like 1 or 2 weeks, of having the capacity to enter into the computer system of the Ministry of Defense and the state and have access to the whole plan of an aircraft or something like that. So that's also where you can turn the analogy in different ways. And I think we need to think about it when we use. And again, for me, where it's changing with cyber and why we may consider having different way to approach the question is because of the scale. We may have a very high scale operation, which is more difficult to have just by physically stealing documents. We saw like the Farewell dossier and others, but still. And we have also how often, again, this may happen. And you have this kind of breach almost every day, which was maybe not the case with documents.
Thank you. Henning?
Yeah, perhaps really just to add on to what Francois just said, I think at a certain point, we should consider that questions of scale become questions of quality. I think it is easy to say that, yes, we've seen it all before. We've seen meddling with elections before. We have seen, I don't know, attacks against civilian assets before. So cyber is just another way to do that. But I think what we have seen is that the attack surface or the vulnerabilities of civil societies have become so much greater because of the digital transformation, because everything is interconnected, that it has become so much easier now for states to try to coerce each other through these means. And I think this is, at the end of the day, not just not simply a question of scale, but also a question of then isn't this a qualitative shift that we need to reconsider more broadly, and the implications of that more broadly. And we can't just say like, oh yeah, this is same old, we've all seen this before, so we can just apply the same legal notions and the same legal considerations that we've always used for these situations. I think there is a larger point to make, that we need to reconsider the way we think about it. And just briefly to the second question, can that be considered an attack? I would say no, and I also want to emphasize that I think it shouldn't ever, because if we start considering these things as attacks within the ambit of international humanitarian law, whether or not I think that IHL is permissive or not, I think I have a slightly different opinion on that than Marco, but still I think IHL is very much necessary and very much in medicine, that if it needs to be applied, we should apply it. But if we start applying IHL to these kinds of situations, I do think that there's a downward spiral there that we might not be able to control at some point.
Thank you. Marco, you wanted to add something?
Yeah, just about the last question, the second question. I'm not entirely sure if it's already been said. Just bear with me. But I think one of the main differences, in addition to scale, as Francois said, in addition to other elements, but probably what is the main difference is between the James Bond kind of spy and the cyber spy, is that, of course, in case of cyber espionage, you can do that remotely. You don't have to go there in person. You don't have to, that's what traditional espionage is about. And that's actually where the IHL rules might reach the stretching point, because IHL rules on espionage are very much, behind enemy lines, based on being behind enemy lines, and that's not the case normally for cyber spies. There was another point about this that I wanted to make, but I'm right. Oh yeah, about whether it is an attack in the sense of IHL. The answer is no. I don't think, even if you to simplify, oversimplify, if and I'm looking at what the prevailing view is in these issues, not necessarily the correct view, but the prevailing view is that if the cyber operation causes physical damage, it is arguably an attack because it results in violent consequences. There is less consensus on whether a cyber operation which results in loss of functionality of physical infrastructures is also causing violent consequences, and therefore it is an attack. But then we go back to full consensus, I believe, apart from one or two cases that I've read, that when a cyber operation does not have effects, either like physical damage or loss of functionality of physical infrastructures, that is not an attack, simply because there are no. So espionage is not an attack either if conducted by traditional means or by conducted through cyber means, in the same way as propaganda isn't. So there might be acts of hostilities, but they are not attacks, regardless of whatever means it's used to carry them out.
Thank you. Vera?
So the question, so I would align with the tenets already expressed by my own colleagues, but I think that the question was more or less about this analogy and use of analogy between online and offline words. So I think that nowadays this analogy more or less works, and you can build arguments based on actually your idea that if it is not outlawed in offline world, where it should be then illegitimate in the online world. But preparing for this discussion, preparing for this conference, and dealing with the question of and approaches to qualified attacks against data as falling under attacks as an IHL notion, and thinking about objects, I was struck by the issue that it seems to me that a number of scholars and the ICRC in general are even, let me use this word, fighting in a good sense, fighting for and pushing the audience, the academic circles, also by this their authoritative opinions to join the circles and actually say that, well, we have to pass this line, and actually data might be protected also by the rules of targeting. And I was thinking, why that? And one of the ideas that came to my mind was that probably this is not a short-term but a long-term strategy, and just think on the development of all our societies as information societies. And I think that in every country, it doesn't matter where you're from, the pandemic has demonstrated that, well, whether lockdown, introduction of QR codes or other things, they have actually transformed hopefully temporarily transformed our life, but they have also demonstrated that you might be extremely, as a person, as a physical person, as an individual, extremely vulnerable when your data may be not only just destroyed, but also just stolen for other purposes. So, and I think that taking into account all the foregoing predictions on where we do move, we can also use our professional imagination to think that, well, probably in the future, who knows when it comes in 10 years or before, in 30 years, the data will indeed play even a bigger role than it plays now. And therefore, probably it is an intention of the wise men to start this discussion, now, and also to get us ready. Let's say, get us ready for these changes. I would not once again say that that IHL is a proper tool for that, but I think that the whole idea that data is extremely is becoming more and more important is a really significant issue to bear in mind.
Thank you very much. Now I would like to ask our speakers if you have final comments that you want to make. Yes, please.
Maybe just briefly, because I didn't have a chance to really respond to Vera's remarks. I just wanted to emphasize that I've found myself very much in agreement also, and I want to share the optimism, Vera, that you mentioned, that you think there is progress in this space, both in terms of how we apply and where we apply human rights law to these situations, but also at the processes of the UN level. I didn't want to be too pessimistic in that space. Maybe I was a little too negative this morning, but I do think that, yes, we are making progress. I think it could be a little more, but I just wanted to emphasize that.
Thank you. Any other comments? Okay, if not, let me thank you, everybody, this panel, the speakers of the previous panel, and also all those who have attended the conference for participating. Thank you also, Gloria, for participating and for staying with us and for the introductory remarks. I hope that you find it informative and that you enjoyed the discussion, and I hope to see you soon to other events at the Geneva Academy. Bye-bye. Have a nice evening or day.